Morning. Good morning, everyone.
Good morning, sir.
Good morning, sir.
Good morning, sir.
Good morning. Well, it's 9:30 and the inquiry is now resumed. Welcome back. As those of you who were present when we adjourned on the 4th of March will know, this is day 6 of the inquiry, and it's now been around a month since we last met. While I don't propose to go through the whole of my opening again, I think it would be useful for us to touch on a few key points. Firstly, my name is Rory Crigland. I'm a solicitor and the inspector appointed by the Secretary of State to hold this inquiry and determine the related appeal. The inquiry is into an appeal made by Anwell Homes Lancashire and Widnes Golf Club under Section 78 of the Town and Country Planning Act against a failure of Halton Borough Council to determine the application for planning permission within the prescribed period. The development proposes for 233 dwellings, reconfiguration of the golf course, demolition of existing clubhouse and associated buildings, and the erection of a new clubhouse and greenkeeper's store, as well as the creation of new vehicular accesses, roads, car parking, a green footpath link, and ancillary development. And all of that would be at Widnes Golf Club, Highfield Road, Widnes. Now, can I ask you all to turn off your mobile phones before we start, and or switch them to silent? And again, please close your email software or set it to avoid notification sounds if possible. Now, during the adjournment, I did visit the site and the surrounding area. The first part of the site visit was undertaken on an accompanied basis with representatives of both the council and the appellant present. Now, this mainly involved visiting Widnes Golf Club and Blundell's Hill Golf Club, and we did also briefly stop outside St Michael's Golf Club as well. The remainder of the site visit was then undertaken on an unaccompanied basis. Now, following the site visit, I issued a draft programme for today. Hopefully you've all received it, but it is available, as I understand it, on the council's website for those of you that don't have a copy. I see we have Mr. Hunter and Mr. Barrett present. I also understand I have representatives today for both the council and the appellate for the discussion on conditions and obligations. Is there anyone else present who wishes to speak today? No. Okay. Now, gentlemen, it may be that things move a little quicker than I initially anticipated. So can I just check whether you're both in a position to present closings earlier if required? Mr. Hunter?
Yes, sir.
Yes, sir.
Okay, great. I'll keep an eye on the programme, and it may be, depending on how the conversational conditions go, we might be a bit ahead of time. Since we adjourned, I've received the following additional documents. I received Mr. Coggin's response to the TEP note on trees, the LPA's position statement on St Michael's Golf Club, the appellant's position statement on St Michael's Golf Club, the council's response to the appellant's position statement on St Michael's Golf Club, and the updated publication of the new local plan, HMRC guidance on the community amateur sports club, and this morning I've received an updated list of conditions, which we will come on to discuss shortly. But I would say at this point, I've only received them just before we came on. I think they were sent in on Friday, but they've taken the weekend to come to me, unfortunately. And I haven't had a chance to look at them in any detail yet. So it may be that we have to move between those documents during that part of the discussion. Before I check whether there are any others, do either of the main parties have any comments on the principle of these being introduced as late evidence?
No, sir.
No, sir.
No, well, I thought they'd be relatively uncontentious, but in that case, I'll add them to my list of documents accepted during the inquiry. Are there any other documents that I should have received or anyone wishes to introduce at this stage? No. In that case, then, before we move on to the first item, which is the update on the local plan, are there any other procedural or housekeeping matters anyone would like to raise? No. In that case, Mr. Hunter, I have received the published version of the local plan, and if I'm correct, the amendment that we discussed previously in relation to the wording, that has been carried through to the new plan. Is that right?
Yes, sir. That's my understanding. Yes.
And for the benefit of those watching, I wonder if you could just give us a brief update on the position, and then Mr. Barrett, I'll invite you to add anything if you have anything to add to it. Mr. Hunter.
I'm sorry, sir. I thought you were asking Mr. Barrett. No, sir. Unless there's anything that you need from me, so I have nothing to add on that.
No, as I understand it, we don't need to have that discussion now. In view of the update being carried through. Mr. Barrett, do you have anything on this?
No, I've got nothing to add, sir. I think the position when we were hearing evidence is exactly as we anticipated, and the plan is in the form that you would have been told it would be, and we note that it has been.
Thank you very much. Well, in that case, gentlemen, let's move on to the discussion on conditions. Will you both be participating in this, or will it be other officers from the council and representative from the appellant?
It will be Mr. Plant, I think, from the council, because Mr. Eaton this was the day he couldn't attend, but Mr. Plant,
yes, I remember.
Issues.
I think it will be Mr. Mitchell and principally Mr. Dorber from Barton Wilmore, who will be discussing conditions. My understanding is that the main parties are agreed, sir, but of course you will want to consider the conditions in the light of your own assessment of them.
Yes. Thank you very much. In that case, I'm just going to turn my volume up because you're both a bit quiet, but then if you can just bear with me for a moment.
So can I just apologise? I've actually got COVID, sir, so I'm not entirely well. So if I cough and splutter a bit, my apologies.
I'm sorry to hear that, Mr. Hunter. Hopefully you're all right to continue. Are you?
I'm fine to continue, I think, for today with what we've got, but I may cough a bit. That's all.
That's all right. In fact, I've seen your light coming on a few times, so that may be why. Well, hopefully you feel better soon.
Thank you.
Okay, I can hear you all better now. Thank you. Now, in terms of the conditions discussion, I'd like to emphasise, particularly for those not participating in the discussion or watching on the live stream, that this is an important part of the process, but shouldn't be taken to indicate that I've made up my mind on anything. Now, I did issue some of my initial thoughts on the conditions proposed, and as I indicated, I have received an updated list, but I haven't had a chance to consider them yet. So what I'm going to suggest we do is that we go through the comments that I've made in each of the conditions in turn. The parties can then highlight any changes that have been made to address any of the points that I've raised, and then there'll also be an opportunity for both parties to comment on those conditions. As no one else has indicated they wish to be part of the discussion, then I won't presumably need to invite others to comment as well. So, Mr. Mitchell and Mr. Plant, are you available?
So I think
or Mr. Dorber.
Mr. Dorber, there we have him. Thank you very much.
Good morning, both.
Morning, sir.
Morning, sir.
As I said, what I plan to do here is just to go through the conditions. There are 31 of them, but I think we can take a bit of a canter through them, and hopefully you'll be able to update me as to where things are at present. Let me just bring up the updated list. And I think the previous list is AD09, which was the one I had been working from. So condition 1 is just the sort of standard general time condition, and condition 2 is plans. I did suggest a separate schedule of plans, which may or may not help, but I can see that you've agreed between yourselves to leave it as it stands and cross-refer back to it as a condition. Is that correct?
Yeah.
Yes, sir.
Okay. I also asked for reasons. Have these now been updated? As I said, I haven't had a chance to look at it, but the previous reasons were relating to the no longer extant development plan.
Yes, sir. My understanding is they've all been changed by the council.
Okay. Yes, I can see. Thank you. I think that addresses that issue. Condition 3, I hadn't raised this condition in my list. This is the phasing details. It's a pre-commencement condition. I did wonder whether the second sentence in that is sufficiently precise to secure the continuity of golf and provision during development. It says such details shall include a plan indicating the division of the development into phases, demonstrating the continuity of golf and provision while the remainder of the site is developed for housing. Do the council have any comments on this?
Sorry, sir. What's the concern?
So I suppose what strikes me there is what I understand it's seeking to achieve in part is continuity of golf and provision for during the entirety of the development.
Yes, that's correct.
And are the council confident or comfortable that the wording is sufficiently precise to secure what it's seeking to achieve there?
I think it was mainly through the course of the construction. It was looking to maintain the continuity of the golfing provision during the construction phase.
So, well, as it's currently written, such details shall include a plan indicating the division of development into phases, and it's the plan that demonstrates the continuity of golfing provision, or is it the details?
I think it would be the details in that plan to show how people would access the golfing provision during the construction phase of that side of the development until the clubhouse, etc., had come forward, sir.
And then it goes on to say the development should be carried out in accordance with the approved phasing plan. Should it be in accordance with the approved details?
Yeah, we can amend that, sir.
Thank you. I'm just conscious that it is a pre-commencement condition, and so if it were to be imposed, we'd need written consent. Well, I'd need written consent from the appellant for that. Mr. Dorber, do you have any comments on this?
No, so I don't see that being a problem. I'll obviously consult my client, but I don't see any issue with that.
Okay, thank you. We may come back to discuss this one. I'll point out later on when we get on to planning obligations, because I think there is a link there that I'd like to explore as well, but it's probably better doing it at that point. So, gentlemen, I'm assuming you're available for that conversation if we need to bring you back in. Great. Condition 4. My query here was whether there was some repetition with condition 2. I don't know if this has been changed at all now.
That's been removed, so it might be difficult to see on the revised version. I think you may have been sent a track change version as well.
Oh, I see. I have both. Thank you, Mr. Dorber. I have both. So it's actually the proposed site levels originally. Condition 4 was proposed site levels, and that's been removed because of the repetition with condition 2.
Correct, sir.
Okay. Then we have 5 and 6. I'm working on, in terms of numbers, I'm working on AD09. And so the numbers are slightly out on the AD055 version that I received this morning. But AD09 conditions 5 and 6 are external facing materials. I don't have any comments on these. Does anyone else wish to raise anything here? No, I'll give you the opportunity as we go through to raise any points that you wish, but I do understand that the conditions are agreed between you. That brings us then on to condition 7. I asked if there was some repetition of the planned condition. This is the landscaping and boundary treatment, and I can see on a quick glance that that's now been amended to remove those and cross-refer to the plans in condition 2.
That's correct, sir.
Yes, sir.
Then we're going on to condition 8, and I asked whether or not the Widnes Golf Club area should be defined by reference to a plan. It's landscaping and boundary treatments, and I can see the plan has now gone in. So I think that one's been dealt with generally, gentlemen.
Yes, sir. Yeah.
Then we're moving on to what was condition 9, which is now condition 8, tree protection measures. Presumably that when you both agree to the wording on this. It's a pre-commencement condition.
Yes, sir. Yeah.
Condition 9. Oh no, sorry. Condition 10. Resident information pack. I don't have any comments unless anyone else wishes to discuss this one in any detail.
No, sir.
Then we have the condition on grid-crested newts. As I understand it, this is this has arisen as a result of the age of the surveys that were undertaken, and that there was some advice that they need to be redone. Is that correct?
Yes, sir. That's my understanding.
Okay. I don't have any comments on the BAT surveys, unless anyone wishes to raise anything there. What was condition 13, which was the Natural England European Protected Species Licence? Is that still in?
No, sir, that's been removed. We noted, the council and the appellant noted your comment in terms of it replicating other requirements, and we've subsequently removed it.
And my understanding is that the appellant would need a licence, and failure to have one when one is needed would be a criminal offence, and so it's dealt with under that legislation and doesn't need to be replicated in planning. That's my thinking there.
That's correct, and I think from memory, the response from Natural England indicated as much in terms of their application response. So the appellant's fully aware of their obligations.
And Mr. Dorber, that's agreed with the council now?
It is, yeah. All the wording as.
Sorry, I meant Mr. Plant. Sorry, I meant Mr. Plant. Sorry.
Yes, that's great, sir.
Yeah, great. Thank you. Then the next one we have is condition 14. There was a bit of, I think, a bit of wording that crept in there that didn't seem to flow correctly. Which one is it now?
I think it was the wording in relation to trees, sir. So
yes.
Bullet point 1 to.
So, but
9
not to the following.
10.
So they stayed in, but the wording is just, as I can quickly see here, some of the wording has just been amended slightly to make sure that the condition makes sense. Now, is that correct?
Yeah. That's correct, sir.
Yes, it still doesn't quite flow, does it? If you look at the first part of the condition, the approved plan shall set out best practicable means to minimise the impact of construction and demolition activities on the site, and shall include but not be restricted to the following. And then it starts to list it, but each of those bullet points, as I understand it, follows on from that first sentence. So it should not be restricted to, and then it shall not be restricted to, a buffer zone of 10 metres shall be established around trees T9 and T11, or shall not be restricted to a pre-commencement check. Okay, that one shall not be restricted to, due to the habitats on sites being suitable, all trenches and excavation should have a means of escape. There's an issue with flow in terms of how that condition is structured, in my view. In days gone by, I would have just amended it to make it make sense, but as it's drafted as a pre-commencement, I think we're going to have to have a discussion around what precise wording we need.
Yes. So I think my understanding, bullet point 9 works, the amended bullet point 9 that starts with works 2, I think that flows.
Yes.
Bullet point 10, that doesn't, so it could be a buffer zone of 10 metres and then cut out shall be established, and then around trees, so it would flow as, but not restricted to, a buffer zone of 10 metres around trees T9 and T11, which has been assessed as having moderate potential for bats.
Gentlemen, what I'm going to suggest that we do here, rather than spend some time now trying to redraft these things, it's not an issue between you of principle, it's just about an issue really that I've raised around wording. And I think on condition 3, there was an amendment that we discussed around the phasing condition. And so while we following on from this discussion, I wonder if you could just get together briefly and agree the wording for those and then try and submit them to me before we close today. So then I have, and any others that we discuss, I have the agreed wording signed off by the appellant on any of the pre-commencement conditions. It'll only apply to the pre-commencement conditions. I'm happy that if there are any other amendments that may be needed, I could make them as outside the inquiry, so to speak, if I were to impose them. But on the pre-commencement conditions, I think I will need you to put your heads together and try and iron out those. They are relatively minor issues, I think. Is that something that you'd be able to do after our discussion this morning?
Yes, sir.
Yep, great, thank you. In that case, let's move on to the next one, which is condition 15 and 16. I did ask if it did strike me, did they need retention clauses as they've got maintenance clauses? Did you have any comments, gentlemen, on that? As these are the lighting schemes, if I recall correctly, AV09. It says that the last sentence, the scheme shall be implemented in accordance with the approved details. So there's an implementation clause and it needs to be maintained thereafter, but there's no need for them to be retained. Is that intentional, I suppose, was my question.
I think when the appellant reviewed your comments, sir, we issued in red some comments to the council. We indicated that we were happy with the retention clause. The council also, from my recollection, indicated they were happy as well. But just looking at this, it doesn't seem to have been added.
Certainly got no objection to that being added. But no, it doesn't appear that they've been added.
Do you both consider that that's necessary and reasonable? My point when I wrote my note was to try and understand what the intention was, whether the intention was to deliberately leave it out or if it had just been left out in error.
I think the original intention was that any scheme put in was there to protect ecology and therefore it was maintained thereafter. I don't think we totally spotted the need for, I suppose, the retention of the lighting to remain. It was just more that they were obviously of appropriate standard for the ecology, but I've certainly got no objection to retained thereafter being included.
No, that's the same from the appellant. As I said, we indicated to the council we could be content with a retention clause.
Thank you. That then brings us on to condition 17. I think there was a small typographical error there, which is
Out needed to be added.
Yes. Sorry, I've lost track of which number I'm on. I've got both documents up in front of me and I'm moving between them. This is the lighting scheme to protect ecology we've done. This is invasive species. Yes, carried out.
Yeah.
No, it's not. It's the landscape and ecological management plan.
Yeah, former 17, now 15.
Thank you. I didn't have any comments on the invasive species condition. Does anyone wish to raise anything on that?
No, sir.
But that takes us on to what was condition 19, which is now condition 17.
Yeah.
Yes, sir.
And I think my query there was whether there was a cross-reference needed to condition 3. I wasn't quite sure whether the phasing in relation to that condition as originally drafted referred to the phasing of the whole of the development or the phasing of the public open space element. So it's this is the second part of the sentence. The scheme shall be fully implemented in accordance with a phasing timetable which has first been submitted to and approved in writing by the council. Was the intention there for that phasing timetable to refer to the public open space part, or is it the phasing timetable that would have been agreed under condition 3?
I think it would be the one under condition 3, but that will include the open space element of it.
Yes, that was what I was trying to get at. The scheme should be fully implemented in accordance with which calls with submission made for conditions. I suppose looking at the redrafted condition, what strikes me is these two conditions could be read to suggest that there are two different timetables being submitted. And my idea of cross-referencing would be this something along the lines: the scheme shall be fully implemented in accordance with the phasing timetable submitted under condition 3, and then it wouldn't need the last part of the sentence, which has first been submitted to and approved in writing, because it will already been submitted to and approved in writing under that condition, as I understand it.
Yeah.
Are you happy for me to make any necessary amendments in the event that I were to impose that condition?
Council wouldn't have an objection to that, sir.
No, sir, neither the appellant.
I don't think it changes the substance of what we were discussing. It just tidies it up a little bit and cross-refers back to the phasing condition under condition 3. Just makes it clear that there is only one phasing timetable and phasing scheme being submitted, and that's the one submitted under condition 3.
Agreed, sir.
Thank you. That brings us on to hours of construction. I think you addressed my comments on that.
Yes, we've amended it.
How it was drafted. It did strike me that it could have been interpreted in a slightly different way, requiring them to carry out works during the entirety of those periods, which might have been a little bit difficult. Then our next one is what was condition 21. It's now condition 19, electric vehicle charging point scheme. I don't have any comments on this. I did notice that there are some amendments proposed to building regulations in respect of electric charging vehicles. I think the government is suggesting bringing in, moving it into the building regs regime from June, but I don't think, as I understand it, I don't think it affects us in this inquiry, and so I don't think we need to get into that. Which then brings us on to 23, which is now 21. And I did ask whether or not it was necessary to specify the works if they're also being tied to a specific plan. Can see that those have been removed to some extent and the plans left in.
Yes, sir.
Apologies, my track change version has crashed. Just bear with me a second.
It's all right, Mr. Lewis. One of the difficulties we have with technology and running these things virtually.
Yeah, I think my computer may have caught COVID from me. No, it's not. I'll work off the revised PDF if that's okay. What number were we on the revised version? Sorry.
On the revised version, we're on, I think, on condition 21, which is off-site highway works.
Off-site highway works, great.
You can see the updates are being made in terms of the reasons. Although previously, I can see now on a quick glance that it previously referred to drawing PL06 revision E. Here we have two drawings. Associated phase, no development shall take place until a scheme for the design and construction of highway improvement works and associated phase in accordance with the site access arrangements shown in either PL06 Rev E or 2224 F08. What could someone explain the reasoning for having an either or plans condition there?
Yes, sir. Excuse me. You may recall from the roundtable discussion on highways, there was a discussion in terms of the a potentially different alignment opposite the former church on Liverpool
Yes.
Road that Mr. Wallerscroft and Mr. Peake discussed.
This is the plan, Mr. Dorber. Am I correct? This is the plan that was included in Mr. Wallerscroft's rebuttal proof.
That's correct, sir. So it had been discussed between Mr. Peake and Mr. Wallerscroft, and the council obviously has seen that. So to give yourself some flexibility, if you believe that 2224-F08 would be a more appropriate alignment, the appellant's position is that either absolutely fine. We accept that that's not the view of the council this time. That was made clear, but we would hope that that would give flexibility to ensure that you could have comfort that the arrangement would work.
Yes. I don't know whether the condition works though, because none of that information is contained within it. And I think it leaves it quite imprecise and uncertain. I can see that there's a bit of a tricky issue to try and resolve because it's pre-commencement, and so we're trying to think about how we could address it. Because as currently drafted, in the circumstance where if I were to come to a conclusion that the second of those plans was acceptable, then it would still, as drafted, allow an arrangement to be carried out or to be implemented in accordance with the PL06 revision E plan, irrespective of my conclusions on it as it's currently drafted.
Yes, I think with the final part of the condition, with the requirement for it to be approved in writing by the council, hopefully that should give some comfort in terms of it would be reviewed by Mr. Peake or one of his colleagues. This would be a further detailed plan that would be based on either PL06 Rev E or 2224-F08. I'm sure Mr. Peake or his highways colleagues would take into account your views expressed within your report in terms of which plan you thought was the best basis for those detailed plans.
Could I suggest, gentlemen, one way around this would be to remove both references to the plans entirely, because whichever plan were to be deemed acceptable, if either, would be listed in condition 2 anyway. And so that would take away any ambiguity or confusion around which plan or any arguments about or potential arguments around this issue, and it would just Mr. Plandit would say something along the lines of, well, it would be essentially the same in accordance with site access arrangements shown in the plans listed in condition 2, or it could just say until improvement works and associated phasing has been submitted to and approved in writing by the council. So it would reserve your position to approve them in writing, but it wouldn't necessarily be as specific to those individual plans. So it would give you the ability to approve them at a future time.
Yeah, I'd agree to that, sir.
Mr. Dorber?
Yes, so I think the position of the appellant will be agreeable to that. I think if the plan 2224-F08 was added to condition 2, just so we have some reference to the arrangement, so we're almost not approaching this from a blank page. There are some parameters established, so the appellant knows what they're aiming towards in terms of their detailed design, as it were.
Yes. Let me just quickly check that PL06 Rev E presumably is already listed in there.
It is.
In condition 2, so it would be a case of if I were to come to the conclusion that PL 06 Rev E was acceptable, it would just stay in. If I were to come to the conclusion that Mr. Woolscroft's amended plan was acceptable, it would just replace the Rev E, the PL 06 Rev E plan in condition 2.
I don't think it's quite as straightforward as that, sir.
Okay.
PL 06 Rev E also, it's basically a site-wide master plan. So that would stay in regardless. I think it would be the case of adding in 2224-F08 in addition to PL 06 Rev E. I think, as Mr. Woolscroft indicates in the round table, it's our position that even if you just kept in PL 06 Rev E, the minor nature of the changes in that area, in sort of the appellant's view, could be covered in terms of the realms of the grey areas in detailed design. But we just wanted to show a more detailed version for you. But yes, I think it would need both added because PL 06 serves multiple purposes.
So in that case, gentlemen, I'm going to suggest that it says something along the lines of no development shall take place until a scheme for the design and construction of highway improvement works and associated phasing has been submitted to and approved in writing. So the in accordance with and the reference to plans is taken out entirely. And then in the event that permission were to be granted, and I would find that the amended arrangements in Mr. Woolcroft's rebuttal proof were acceptable, I would add in the 2224 F08 plan to the list of plans in condition 2.
Yes.
Mr. Dover, do you want me to run through that again?
Yes, please. Yeah, I think I've got a bit of a. I should specify. Like Mr. Hunter, I've succumbed to COVID over the last week, so I'm a little bit foggy today. Excuse me.
Okay, that's fair. I think, gentlemen, that works. And it takes out the ambiguity of having two plans on an either-or basis there, because I think that there is a bit of confusion, and it would only really make sense when read in conjunction with my decision. And I think the condition should probably stand on its own feet in that sense. So this is one of the pre-commencement conditions, and it's something that you could possibly look at along with the other conditions that we discussed earlier on when we finish this conversation. And I'm happy when we come back before we finish the discussion on obligations, if you want to have a conversation, gentlemen, and let me know whether or not you're happy with that wording, and we can touch on it again if you've got any concerns there, Mr. Dover.
Thank you, sir. Yeah, I think it would be useful to discuss it with Mr. Plant.
Thank you. In that case, moving on then to parking and service provision, which is now condition 22, but was condition 24. I think there was some, I think that pointed out there's some unnecessary repetition in the wording. We had there.
I think it was the plans against that we've added in a
Yes.
cross-reference to condition 2.
Okay, thank you. I think that one's been dealt with. That takes us on to 25. I wondered whether occupied was the correct term here. The golfing provision, the reconfigured golfing provision shall not be occupied.
Again, we've agreed that, yeah, occupied clearly isn't the right word there, so shall not be brought into use is
Thank you.
amended.
And then condition.
And again, the condition, yeah, with the plans, sir.
And then condition 26, which was the new footpath. I wondered whether there was a bit of tension here between the idea of adoption and ongoing maintenance. I don't know if you had any thoughts on this, gentlemen. I think it started off as drafted, and I don't know if it's been changed now, but it started off as it was, a detailed scheme to be approved that is capable of adoption. And then the approved scheme shall be fully implemented in accordance with the agreed timetable and maintained thereafter. Presumably, the purpose of it being capable of adoption is for it to be adopted. And then if it were adopted, does that maintenance obligation stay with the developer or move to the council, or how does that work? Does it invalidate?
I think in
discharge
terms
condition?
of how the council had considered it, it was that it was capable of adoption. That was the standard of the path, rather than it being about whether we would necessarily adopt it. Obviously, if those discussions were had separately, then that's fine. But it was just to indicate the standard.
Fair enough. That clarifies that. Thank you. And so I assume no changes were made to that condition.
Correct, sir.
Thank you very much. That takes us then on to 27, which was implementation of noise mitigation measures. I don't have any.
Again, sir, it was just a cross-reference.
Cross-reference to the plans.
Yeah.
Yes, I think that works better. And then ground contamination. I don't have any comments on this. I've assumed that this is part of the wider contamination issues in the area rather than any specific contamination. Is that right?
Yes, sir. I think it's just mainly condition the further work and the remediation.
I think the only specific points are in point A in terms of where it references section 17 of the ground investigation report. So that will cover up any specific bits.
Thank you. 29, approval, whether it should be in writing, just to tie in to the other conditions. I'm assuming, gentlemen, that's carried over.
Approved in writing has been added, sir.
And then condition, I don't have anything on what was condition 30, which was implementation of the drainage scheme, which is now 28. And then condition 31, which was foul and surface water, whether or not there was replication with other regulatory requirements. And I can see that looks as if it's been removed.
That's correct, sir.
Great. Well, I think that takes us through all 31 of the conditions that were originally proposed. We're now down to 28. Before we finish this part of the discussion, does anyone wish to raise anything else in relation to the proposed conditions? No. Thank you, gentlemen. I mean, I think having an opportunity to send that out to you and for you to have a look at it before we came to the discussion, I think that saved a bit of time and made that discussion a lot smoother. If I could ask you, as we discussed, to just have a look at those few pre-commencement conditions. I think it was 3:13.
Could have been new 13, but 12. Yeah, I've got 3:12, possibly old 15 and 16, 17 and 23. I think there's the ones I've noticed.
That's what I've got. So yeah,
Excellent.
Condition 3, condition 14 as was now 12, condition 15/16 in the new numbering, 19, old 19 now 17.
I'm sorry,
and
could you run through those again for me, Mr. Dorber? And I'll make
yes, I'm trying to clarify in my own mind as I run through the numbers that I've got jotted down. So condition 3, which is consistent between both versions. The old 14, now 12.
Yep.
New 15 and 16. I'm not sure what it is on the old one. That was around about the time my computer crashed. Old 19, new 17. And the former condition 23, which I think is 21 now. If someone could confirm that for me, I'd be grateful. Yeah, that's right. So those are the ones that I had.
Thank you. Gentlemen, if you could have a quick look at that. I can see that AD 55, which is the newer draft of the conditions, isn't signed anyway, and so it's probably useful.
I think it should be, sir. I think it's not signed. There wasn't enough space to sign it on the dotted line, so it's on the subsequent page.
Mr. Dorber, would in view of the fact that these amendments are for pre-commencement conditions, would it be difficult to have that signed before the close of the inquiry?
No, I know the signatory is listening in on the live stream link, so I'll get in contact with him once I've discussed the changes with Mr. Plant, and we should be able to sort that before closings.
That's great. Thank you very much, gentlemen. Is there anything else that you'd like to raise in relation to conditions?
No, thank you.
Anything anyone else would like to raise in relation to conditions? Thank you very much. That part of this discussion is now closed. And gentlemen, you can turn off your cameras and your microphones. Thank you very much. Okay, moving on to the next part of our discussion, which is on planning obligations. Gentlemen, I originally had Ms. Lisa Ty from Shoesmiths for the appellant, and I had Miss Elizabeth Wilson Lagan. I'm going to have a go at that pronunciation. It could be slightly different for the council. Is that still the case?
So yes, that is the case, and I've just noticed that Miss Ty is present. The virtual inquiry.
Thank you, Mr. Barrett. Good morning, Ms. Ty, and Mr. Hunter for the council.
So I had asked that question and I hadn't got an answer to it, and I still haven't got an answer to it. So I was looking through the list of attendees, and I can't see her name on it. It may be that there was an issue with her being able to attend today. So would you just permit me to turn off my camera a moment and see whether I can make contact just to check? So maybe that's something I'm going to have to try and help with. Thank you, sir. Yeah, I've clarified that she's not available. I'm afraid that the message, I think it got lost in the ether to me. So I think it will be Mr. Plant and myself doing our best between us to help you with this.
Mr. Hunter, I don't want to sort of just surprise you with this. If you'd like a short adjournment to have a discussion with Mr. Plant, then I'm happy for us to take a short break of 10 minutes now, and you can have a discussion with.
That might be helpful, sir. Actually, that just to double check and have a chat and see. Thank you.
In that case, it's 10:22. Let's adjourn until let's say 10:35, and then we'll come back and have the discussion on obligations. Is that long enough for you, Mr. Hunter?
Yes, that should be fine. Thank you, sir.
Okay. In that case, the inquiry is now adjourned until 10:35. Thank you.
Thank you.
Well, welcome back, everyone. It's now 10:35. Inquiry is now resumed. Mr. Barrett, are you with us? I think we'll wait just for a moment for Mr. Barrett to rejoin. Mr. Hunter, can you hear me, Mr. Hunter?
Sir, yes, sir, I can. Thank you.
Mr. Barrett, are you back with us?
I am, sir. I don't know what happened there. I fell out. I think it was the broadband width here, but I think everything's okay now.
Oh, fantastic. I just wanted to say, Mr. Barrett, that while I know that Ms. Ty will be, or I understand will be leading on this, then, do feel free to participate, particularly as I'm assuming, Mr. Hunter, you're leading for the council. Is that still the case?
Yes, I'm happy to do that, yes.
Thank you.
Thank you, sir.
Well, similar to our previous discussion, I'd just like to make clear this part of the process is or should not be taken to indicate that I've made up my mind on the application. That will only happen after the close of the inquiry. Now, as I understand it, there are 5 main obligations proposed: the use of proceeds, the Widnes Golf Club works, the Blundell's Hill Golf Club works, the open space management plan, and affordable housing. Now, I intend to go through them all one at a time, but before we do, I do have a few general points I'd like to check. Ms. Ty, good morning and welcome.
Morning.
I just have one or two the sort of general points really I wanted to just check with you. Am I correct on my reading of the unilateral undertaking that the only land being bound by the obligations would be the residential development site and not the wider golf club land, and none of the obligations are seeking to bind the land forming part of Blundell's Hill?
The latter part is correct, sir, that nothing is seeking to bind Blundell's Hill, because we don't have the owners of Blundell's Hill as party to this.
Yes.
But it's not purely the residential development site. It does include the golf club. The wider Widnes Golf Club land is being bound, and so there is that is to secure the carrying out of the Widnes Golf Club works, albeit that in effect the bit that bites is the restriction on the residential development part of the site.
Okay. Well, might need to assist me a little bit there. I've just put up my unilateral undertaking. So it's the golf club works. The restriction links to the residential
Correct.
part. But then some of the others bite onto the whole of the land.
Yeah, in terms of the land that's bound by the undertaking, it's the site which is defined as the whole of the site. So that comprises both the residential development site and the wider Widnes Golf Club land.
Whole of the land complies and edged red. And then the residential development site is shaded pink.
Correct.
Thank you, that's useful. And then my next general question, Ms. Ty, is in relation to St Helens Borough Council and why they've been included in the unilateral undertaking.
It was more, obviously there are works contemplated in the undertaking that are within St Helens Borough,
yes.
But that they're not kind of party to it in the sense of they won't be able to directly enforce those works, because the bit that bites is the restriction on the residential development site. It was more to give me, so we did send the draft to St Helens, and they did come back just to say they have no positive or negative comments on the draft because no development is before them in effect for approval. So it's more, I guess it's more for information that it is something that we are saying we will do those works that do happen to sit within St Helens. So we're giving that undertaking to both authorities.
But the purpose of including Halton Borough Council in the unilateral undertaking is because they have rights to enforce under it, whereas,
correct,
if I understand correctly, St Helens don't.
Correct.
So their role within it seemed a bit unclear to me, really.
Yeah.
I suppose my next question then is does including them impact at all on the undertaking itself?
No, it doesn't, sir.
Mr. Hunter, do you have any comments on that?
Thank you, sir. No, I think I had the same query really about the St Helens status. I think they're kind of in no man's land. The undertaking is addressed to them, but it's not enforceable by them. But I don't think that. I mean, I don't know why that is, but I don't know. I don't think that necessarily causes any great difficulty. It's sort of a bit of loose machinery.
Okay, thank you. Looking then, what I'm proposing to do is that we go through each one of them and have a quick or sometimes slightly longer discussion on some of the points. I've also got a few questions, Ms. Ty, as we move along, and Mr. Hunter, I'll give you an opportunity to confirm the council's position, which I understand you've already submitted in writing, so I have all of this information before me. So the first one is the use of proceeds. Ms. Ty, I'm going to start off just by explaining what my understanding of it is. Please do correct me if I'm mistaken, but my understanding is that this requires the appellants to use the proceeds of sale only for specified purposes. Now, I don't think this is covered in the sale compliance note, but I'm assuming that along with the obligations in relation to the works to the golf club, that the intention of this is to secure the equality of or better provision as required under paragraph 99B of the framework and what is now policy HE6 of the new local plan. So it goes to the idea of equality of or better provision.
Yes, I'm slightly hesitating because the plan policy bits are not my bag, but yeah, that's the intention.
Okay, Mr. Hunter, what's the council's position on the obligation generally?
So I think so, as you've seen in the position statement, I think the key point for the council is just that none of these obligations are apart from I think the affordable housing and the open space obligations, which would be required as a matter of course and are necessary to make the development acceptable in those terms. I think in terms of the Blundell's Hill and the acquisition and the Widnes Golf Club and the Blundell Hill work, the council's view is that they weren't necessary because they aren't things that the council thinks are capable of overcoming the objections. That was the essence of I think the council's position in relation to most of those three obligations.
Ms. Hunter, what I wasn't sure on in terms of the council's position, and I'll just stick with this one, but it does apply to the other two in relation to the golf club works as well, is it almost read as though the council were reiterating the arguments that we had in terms of the golf provision evidence that the appellant has made out their case and therefore these are not necessary. Obviously, this discussion needs to happen on the basis that if the appellant has made out their case, what's the council's position? And so what I'm trying to get at here is if I were to find that the appellant has made out their case in relation to paragraph 9, I'm going to use the framework references just because they're clearer in my mind, but do carry them forward as well into the HE6 policy. But if I were to accept the appellant's position in relation to paragraph 99B, equality of provision arguments, then is the council's position that these obligations still don't meet the tests?
So I suppose it depends, sir, on your specific findings. But if I start with the assumption that you find that all three things, the Widnes Golf Club works, the
Mr. Hunter, let's just do one at a time because I know it's easy to bring them in, but I'd like to look at them individually because there's some crossover, but there are also some differences.
So I think what I'm saying is, so if you were to, it depends on what you find is necessary to pass the 99B test. If you find that all three things or some combination of those things are, then contrary to the council's case, then yes, sir, I think it would. You could be satisfied as it passed the Reg 122 test. I think it is. I appreciate entirely what you're saying, sir. And I'm going to try. I had the same thought when I read it. It is a little different. I was thinking that there's a point taken, at least partly, about directness as well. And I can see that there might be some arguments about whether Blundell's Hill is directly related to the golf club. So, but as I say, I suppose it depends on what you find. If you find that these things are sufficiently connected and do justify the loss of the part of the existing golf course, then so I think it kind of does follow that the Reg 122 tests would be satisfied.
Okay, so looking purely at this idea of the proceeds of sale, the council's position would be that if I were to find that paragraph 99B is satisfied by the appellant, equality of provision, that this would be necessary to make the development acceptable in planning terms, but also meets the other tests as well in terms of section 1061. So Ms. Ty, I'm going to come on to this with you in a moment, but it restricts the use of land or development, requires specified operations or the land to be used in a particular way, or requires the payment of money.
Right. So just bear with me. As I say,
I know you're on.
No, it's quite all right. I mean, I have read it. I haven't thought about that particular question. So just bear with me 1 second. Well, so, I mean, I now you have raised it, sir. And I don't know whether this was something that you were thinking or driving at behind it, but so I'm just, I'm at the 1061 point. I am not clear, and maybe Ms. Ty can help us on this, how the obligation to use the proceeds only for this purpose fits within 1061.
Ms. Ty, that is the next issue I'd like to come on to have a discussion around. What your sole compliance note does go into detail on the golf club works, but it's quite silent on this first obligation. Is the appellant's view that it's capable of being a planning condition and fits within section 1061?
It is about the golfing facilities at Widnes Golf Club and at Blundell's Hill. So it is ultimately about the use of land, because it's about how that money can be used to improve those facilities. And in reality, the only way that Widnes Golf Club can get to the point of improving those facilities is to take control of Blundell's Hill Golf Club in the way that the agreements that obviously sit outside of the planning process and are between Amwell and the golf club. It is the only way that can happen, but ultimately it is about improving the facilities that are on land. So it is about the Widnes Golf Club and about Blundell's Hill, and about improvements ultimately that will take place there. But the only way to get to that point is to use the proceeds to acquire Blundell's Hill. So
which part of section 1061 is the appellant relying on in terms of this obligation? Which
it's the use of land, because we're clearly not paying money to the authority.
So you're looking at land being used in a particular way.
Yeah.
And so what land is that?
It's the wider golf club, Widnes Golf Club site, and it's Blundell's Hill.
Well, I think we established earlier that Blundell's Hill wasn't being bound by this. So in terms of the land being bound, it's the wider Widnes Golf Club site.
It is.
And how is it being restricted or bound in that sense? Because it's not saying not to carry out part of the development until these things happen. It's just saying the proceeds of any sale must be used for a specific purpose. So how does that fit within the idea of requiring land to be used in a specific way? How does it bind that part of the site or that?
Because it's about the purpose of the use of that money is then about making improvements to the land in a particular way.
But as a restrictive covenant, what land?
It's not a restrictive covenant. I don't think it's required to be a restrictive covenant under section 106.
But it needs to flow with the land. So if the land were to be sold post any consent being granted, would this flow with the land?
Well, it would. It would flow with the land, but it would need to be part of any sale of the land.
Thank you, Ms. Ty. I'm not sure I entirely follow how it's being bound. If I'm being frank, I can see that it requires the developer to use the proceeds for a specified purpose, but if they don't, how does it bite? What happens if they don't? How is it enforceable, I suppose, is the question.
Well, I mean, it's enforceable in the way that a 106 is enforceable generally. The authority have powers of enforcement of Section 106 obligations.
But it doesn't restrict their use of the land, so they could presumably not comply with it, carry out to the development anyway. And then I suppose my next question then is how would the authority know? How would they know whether the proceeds of sale or the entirety of the proceeds of sale have been used for those purposes?
I mean, I think that the reality is that it reflects what the club are going to do, no matter whether this is in the unilateral undertaking or not. And it's about the way that the club is set up as a community amateur sports club means that they're bound to do this in any event by rules that are beyond Section 106. Because they're only allowed to exist for the purpose of improving sporting facilities because of the way that they're set up and registered.
But they're not bound to do these specific things, as I understand it. They're not bound to carry out to use the proceeds for these specific purposes under the community rules.
No, but they couldn't use it for anything else. I think the council made a comment that the money's going to go into the pockets of individual members of the golf club.
That's not where I'm going with this. With this, I'm trying to understand, and I'm sure you're aware. My purpose in this conversation is to really understand whether or not these obligations meet the tests, and if they do, how so. Mr. Barrett, I can see you've got your camera on. Did you want to come in there?
So yes, if I remind myself of Section 106(1)(c), requiring the land to be used in a specified way. So there are two elements perhaps to the case. One, there is the obligation under Section 106 that Ms. Ty has addressed, but that comes in circumstances where Her Majesty's Customs and Excise has an interest in what proceeds are available to the club and how they are utilised. The club doesn't really have an option because it's enforced by Customs and Excise, but to spend the monies on sports-related facilities. Now, some of them may or may not need planning permission, but the one thing that you, sir, as a decision taker can be assured of is that it's not a case of members or the executives of the golf club being able to pocket any of the proceeds, wind up the company and divide the spoils amongst themselves. That's not an option. So, and it's for that reason that we put in the government guidance in relation to the management of the club and how the constitution of the club has to be set up so that the inland revenue advantages that we're provided with, or the revenue matters that we're provided with, the advantageous circumstances are maintained. And I think that advice is very clear, sir, if you've had an opportunity to briefly consider it, as a degree of assuredness that the policing of the proceeds is essentially that for customs and revenue and customs, not so much local planning authorities, but the consequence of the status of the club ties in very closely to 106 1A, B and C, because the site's use will be restricted to that of a sports facility. The specified operations would be limited to only those specified operations that would be associated with the club, and the land would have to be used for sports purposes, the golf club purposes, in accordance with our constitution. And if we don't, then we answer to Customs and Excise.
I suppose that brings me on to the next question then, Mr. Barrett, as to why this would be necessary as a Section 106 if it's already covered by HMRC Customs and Excise rules.
Well,
because obviously my consideration of these has to be on an individual basis and they have to meet the test. So
yes.
How does it meet the CIL and the framework tests?
Well, there's a level of assurance in that there are certain triggers in the 106 in terms of the right to occupy certain parts of the residential development, which provides the local planning authority with the assuredness, both in terms of timing and delivery, that this will occur. That would not be something that the Revenue and Customs would be able to control. That's why we've got, if you like, a belt and braces approach, because we've got the mechanism that deals with this cannot happen until, sorry, you can't occupy X number of houses until you've satisfied this staged approach. That's something that's out with the Revenue and Customs guidance and control, but is something that is important for the local planning authority if this development is to occur.
Yes, that touches on the second two, though, doesn't it? It touches on the Golf Club works and the Blundell's Hill works. It doesn't necessarily touch on the proceeds of sale obligation, because this is a separate obligation to use the proceeds of sale for specific purposes. And if I've understood you correct, Mr. Barrett, you're saying that effectively the local planning authority wouldn't be the enforcer here. It would be Customs and Excise, HMRC. That's
right. So we're giving it as a degree of assuredness that the expressed intention that's always been expressed by my clients will actually be delivered.
So it is also back to if you found that it wasn't within Section 106 in the usual way, if you at clause 2.1 of the obligation, it's expressed to also be under Section 111 of the Local Government Act, which is the general contracting provision that enables parties to enables local authority to enter into contracts generally.
Yes. Okay.
I think it's probably also fair to say, again, I know these aren't things that are before the inquiry, but it does reflect the contractual position as well that sits behind all of this between the golf club and Amwell.
Yes, I don't have details of that, though.
Yeah, no, understand.
And so while I take Mr. Barrett's point in terms of the enforcement mechanism from HMRC, there's no certainty, if I understand it, that the proceeds of sale would be used to purchase the golf club. Is that fair? Where's the certainty?
Under the HMRC rules, or under this?
Well, under either. So under the HMRC rules, there's no requirement, as I understand it, for them to purchase sale, because those are general rules that apply generally to everyone. So they don't apply. And the obligation that I have here in terms of using the proceeds of sale only for that purpose isn't enforceable by either HMRC or the council.
Well, it's enforceable by the council as a contractual provision. So it is it is a clear it is a clear obligation on the golf club to only spend money in that way that the council could enforce.
But how would the council know, Ms. Tye, that they'd spent it in that way?
Well, there's obviously provisions for discovery and pre-action letters and everything that comes with litigation.
But then that would place quite a strong onus on the council to do some investigatory work and request significant amount of financial detail, as I understand it, from the appellant, as to whether or not those proceeds have been used in the way suggested here and in accordance with the share purchase agreement, which we don't have a copy of. I'm just trying to work out how this obligation in isolation is workable. Mr. Hunter, do you have anything that you want to comment on this?
Yes, I have a few points, if I may, Mr. Arnold. The first one is there was a reference there to money in pockets. So if that was based on anything that I may have said before, then it was the wrong impression. There was obviously no suggestion of that, so and I just want to be clear that wasn't anything I was suggesting about the golf club. But the issue is, so obviously, you know, there's either a point to this obligation or there isn't. And the point seems to be to give the council control and to know that money's being put towards the golfing facilities and provision and spent on Blundell's Hill and so on. And so it hadn't occurred to me before, but now I've looked at the section 1061 point. I don't see an answer to it, and I don't think you've heard an answer to it, because as you sort of pointed out, the provisions regarding restricting are all about the use of land and so forth. All it says about money is paying money to the council. So it's just not something that I can see how one could draft an obligation to have the same effect, much like a Grampian, because you'd link it to some restriction on the use of land. But that's not this obligation. So as the obligation is drafted, so I think on the original point you raised, seems to me that it doesn't come within any of the provisions of 106.1. Does that matter? It may not matter in reality, because your second point, sir, which is the point that the council has taken, which is how would we enforce it anyway? Ms. Ties said we could get discovery. Well, so that I mean, it's not realistic, and it would, you know, it isn't reasonably enforceable by an authority if it has to go to those lengths to do it. So those are the two key points, I think, sir. One of the minor point was section 111. It was said, well, if it's not within section 106, the undertaking refers to section 111 of the Local Government Act 1972, which is the incidental power. The main problem I see with that is that's a power for the council to do something. This document is not a council document, it's a unilateral undertaking. So section 111 doesn't seem to me to have any relevance to a unilateral undertaking.
So we would have liked to have had an agreement with the authority, but the authority didn't want to enter into an agreement, so we had to go down the unilateral undertaking route.
Ms. Imus, do you wish to respond on the points that Mr. Hunter has made in relation to the enforceability of the obligation and the other points he's made around section 106.1?
I really don't see any problem with in terms of enforceability because it's an undertaking made by deed. It doesn't have to be supported by consideration. It's a clear enough obligation, and Learned Friend really is referencing the difficulties associated with enforcing it. Litigation commenced, or letters before action, and litigation commenced, but that's an inevitable consequence of the enforcement of any planning obligation. If there's any difficulties associated with it, with enforcement, it's a product of the section 106 regime itself. If somebody is not complying, the council would have to resort to litigation. And so the point that I was making...
Sorry, Mr. Barrett, I suppose the point, though, that I raised is how would the council know whether or not those proceeds... So if we look at the second obligation, where it's not to occupy more than 125 dwellings, that's something that the council would be able to identify relatively easily by going on site and seeing how many dwellings have been occupied. Yes. But in terms of the first one and how those proceeds of sale are to be used, how would the council be aware of what Widnes Golf Club have done with those proceeds of sale? Presumably they'd have to wait until the accounts came out. Is that how they discover it?
So there would be the relatively simple expedient of open correspondence, and if the club or their successors were reticent in providing that information, there would be recourse to litigation and discovery, as Ms. Ty said. But there is also that's why we've done it as a sort of belt and braces approach. There is also the degree of assuredness that in my submission, the council is entitled to rely upon is the status of the club itself. It is beyond the club's power to deal with the proceeds in any other way than is provided for in the Section 106. If it did, it answers to the Inland Revenue. I suppose by parity reasoning, one goes to the issue of, if I was undertaking to do works that would require the consent for such works and the continuation of such works, say with the Environment Agency, am I giving an obligation that will be monitored and enforced by another body, particularly a public body, is an appropriate degree of assuredness to the local planning authority that the proceeds will be dealt with in that particular manner.
That presumably goes to the final part of that obligation, in that if the proceeds can't be used for 1, 2, then they'll be used for 3. So if they can't be used for obtaining control of Blundell's Hill, the carrying out of the golf club works and the Blundell's Hill Golf Club works, then to the extent that they haven't been fully expended, they would then be used for the benefit of golfing provision or golfing facilities at Widnes Golf Club, presumably not in that case Blundell's Hill if they haven't been purchased, and that's the final part of that obligation is where the HMRC bit comes in, because my understanding is that the other parts aren't really touched by it.
Yes, and so there's another element of the cudgel or the sword of Damocles hanging over us, hanging over both the club and the developers, is that without completing the Blundell Hill Golf Club works as defined in the one obligation, that there's a limit to the number of houses that could be occupied. So it's
yes, I think we'll come on to that in a moment, but that's conditional, isn't it? Upon that's a contingent obligation, which is based on them obtaining control of it and obtaining planning consent, if I understand how that's drafted correctly. So if neither of those things happen, then that restriction doesn't bite either.
I don't think it's right to say that it's subject to control being obtained. It is subject to consents being obtained, but it's not subject to the control being obtained. If you look at clause paragraph 6.
Okay, yes, subject to all necessary to carry out a complete.
So it is an absolute it does of itself create an obligation on us to make sure that we do get control of Blundell's Hill. And from the house builder's perspective, that's why it is backed up by contractual provisions and step-in rights that I appreciate aren't before the inquiry.
So I think we might need to touch on that point in a moment when we come on to it. I hadn't appreciated that. I'd assumed it was contingent on both parts, so it might be something that we need to discuss in a bit more detail in a moment.
So I just have a couple of points. Mr. Barrett's point about the simple request for information, but so we're talking about the proceeds, but we haven't been. I mean, one of the features of this case is we don't know what they are. We haven't. There hasn't, for perhaps understandable reasons, they've remained confidential. So. And the problem is, so I don't want to sound like I'm casting aspersions on anybody here, but what we're talking about is a legal document and what legal mechanisms there are in place. So I'm not casting aspersions on it. I'm just looking at the document, sir, as you are, I think, asking how does this allow the council to do what it's intended to do, and if I can't see if. I'm hypothesizing, and I say I'm not casting aspersions here. This is just a wild hypothesis, but the obligation should deal with it, which is, what if the land is sold and the next owner of the land doesn't want to tell us? So there's nothing in the obligation that says that they have to. And the other remedy that we've been suggested was that we should go to court, but we'd be going to court knowing nothing. And that's not usually a very good position to go to court in. It may, but so as you said, I'm not saying that these things are entirely insuperable, but at the moment it's a very difficult obligation to enforce. It's not obvious how we can do it. And as I say, I doubt many authorities would want to police some a private entity's bank account, and we're not given the tools to do it here. And I'm not saying that the club will be recalcitrant, but a successor in title might be, and the obligation should deal with it. So that the second point that I wanted to raise was, although we probably will come on to it. So I'm not. I'm new to the cask guidance, but just looking at that, so I think so. I'm not sure it's. I think certainly. So I agree with what you said, that there's nothing in that which would limit, as far as I can see, the club to or require the club to purchase bundles, hill, or spend money on particular works. But even the more general obligation, the third one, to use the remaining proceeds for golfing facilities at those two clubs, that's narrower than the general power under the cask. They simply have to reinvest the proceeds in the club, and there's discussion there of paying people things that could be spent in all manner of ways. The principal restriction seems to be simply that they can't distribute it amongst the members. But there's still quite a lot of things they could do with the money that would fall outside the obligation that we're looking at. So those are the points I wanted to raise.
Thank you, Mr. Hunter. Ms. Barrett or Ms. Tye, do you want to come back on any of those?
So I think it's simply wrong. The proceeds will be certain that they will be a matter of fact, and because of the nature of the registered title, they will be a matter of public knowledge in one sense. I don't see any difficulty with the ascertainment of the amount of the proceeds, and I don't see any difficulty whatsoever with reposing some trust in HMRC to control the funds. It is simply, once the club has taken the advantage of becoming the special vehicle that gets the advantages, the revenue advantages that it has, it cannot do anything except use its receipts in accordance with the guidance that's provided. And yes, that there can be all sorts of expenditure, but it must be referable to the purposes of the club and the sports facilities. It's simply not an option under the guidance for the proceeds to be misappropriated. Now, I don't think I can add anything further than that, because that's what the guidance tells us.
Yes, Ms. Barrett, I'm not sure that there is a suggestion around misappropriation. I think this is about whether or not the obligation meets the tests. And I suppose I'm a little bit unclear on is if the HMRC controls are sufficient, why is this necessary, and how does it meet the test of being necessary in planning terms?
Well, sir, I was making the point earlier that it was to provide a degree of assuredness to the council, and to bolster the point that we make at 6 and 7, that the proceeds will be spent in a particular way, and there will be control really via the mechanism of the right to occupy the residential component of the development that will be prevented unless we do that. So we allied two issues. First of all, the fact of control from HMRC, and also the assuredness that we give in the obligation that the proceeds will be dealt with in a certain way, which is consistent with our obligation to HMRC in any event. But more particularly for the purposes of the Section 106, what really bites is the inability to complete this development or further the development without doing these works.
So is it a standalone obligation, Mr. Barrett, in your view? One, proceeds. Or is it linked, inextricably linked, I suppose, with 2 and 3?
Well, certainly it is intended to be inextricably linked. They are to be elided together. They are part and parcel of the proposals package that we have put to you, sir, in accordance with our case under policy 99B.
Okay, so the proceeds, the golf club works and the Blundell's Hill Golf Club works are all linked together, and then the open space management plan is a standalone obligation, and the affordable housing is a standalone obligation.
Yes, they are complete. They are separate. They would be obligations that would arise in any event.
Okay, thank you. That's helpful. Does anyone else have anything they'd like to say on this before we move on to? I do have one other question actually, but on the points that were made. Mr. Hunter, do you have anything? Ms. Ty?
No, sir. Thank you.
Okay, so then my next question on this obligation, and I think we'll retouch on this question on the other two. I have dealt with them separately in my preparation for this discussion, so I will continue along that basis, but thank you for the clarification that they are linked. What I'm wondering now is how this and these other obligations would be affected if I were to find in favour of the appellant on the surplus to requirement point under section 99B of the framework. So as I understand it, Mr. Barrett, and I haven't heard your closing yet, but based on our previous discussions, the case being advanced by the appellant is that the provision, the Widnes Golf Club is surplus to requirements, and if I were to find for the appellant on that point, I wouldn't then need to go on and consider the second point under 99B around equality of provision. If that were the case, are these obligations then still necessary?
Well, they wouldn't be necessary because in those circumstances, you would have found that I'll put this in a more vulgar expression, there isn't a downside which we need to make good, because if it's surplus to requirements, it's surplus to requirements. I think we have what's called a blue pencil clause.
We don't, but we deliberately don't have one because these are the works we are going to do in any event, whichever way you find, sir. These are works that are intended to be carried out. So I appreciate that's a slightly different point to whether they are necessary, but we deliberately didn't include a blue pencil clause because from the golf club's perspective, these are works that they are committed to carrying out.
Well, they have to do anyway because of their obligations to the revenue. So, but I don't think that removes my point. So your conclusions would actually, in your decision letter, were you to make that finding, it would be absolutely clear to both parties that in those circumstances you would be giving no weight whatsoever to the obligations that were contained in the section 106.
So thank you, Mr. Barrett. So it would just be a case of, in that sense, me specifying that as a result of that finding, were it to be made, then these obligations, notwithstanding any lack of blue pencil clause, I wouldn't be taking them into account or giving them any weight.
You wouldn't give them any weight, sir. Self-evidently, save for the affordable housing and the open space.
Yes, I think in terms of we'd have to treat those ones separately. This is just in terms of the framework 99 issue. Mr. Hunter, do you have anything on that you'd like to say?
Thank you, sir. So, would you just let me think about it for a moment again, because the thought that's in my mind, and I just like to mull over a second, is some of the golf club, Widnes Golf Club works are part of the planning permission that is sought. So I just want to think that through. For example, the clubhouse. And so what I'm thinking is this. So, no, I was in the circumstances where you don't need to rely on the equivalent provision, I think I agree with Mr. Barrett, having thought about it, because I mean, what I was just mulling over was that in that scenario, absent the obligation, the planning permission, I think, I don't think there's anything in the conditions wouldn't necessarily require the golf club, the clubhouse to be built at all. So the permission for the housing could be implemented, but unless I missed something in the conditions, if there isn't a specific condition requiring
compliance with plans condition there, isn't there?
There is compliance with plans, but you don't necessarily have to carry out all of the development for which you have planning permission, absent a condition or a unilateral undertaking to require it. So if, as I say, scenario, the permission is granted for everything, the southern part of the site is sold and will build the houses, but nothing happens on the golf course. I'm not sure that, absent the unilateral undertaking, there's anything that would require the golf club to implement all of the works on the golf course. But the reason why I came to the same view as Mr. Barrett at the end was, in a situation where the golf club is found to be surplus to requirements, planning policy doesn't require them to do anything. They can clear the site if they want, or they can leave the site as they are. If it's surplus to requirements.
And so they'd be in the position, as you said, to choose whether or not they wanted to implement any of those works. And I think Ms. Tyers mentioned that they would do so anyway because they're under other contractual obligations to do so.
Well, maybe, yes, sir, but from
our perspective,
it would be open to them not to.
Okay. Thank you, Mr. Hunter. Mr. Barrett, is there anything else, or Ms. Tyers, that you'd like to say in relation to that obligation?
At a pure practical level, that interpretation is absolutely right. There's nothing by way of condition or obligation that requires the works to the golf club itself, the physical works of the golf club, which we seek planning permission, to be completed by a certain time. All I would say is, sir, if that is a concern, and whilst Mr. Dauber and Mr. Plant are busy scribbling on the conditions, if that is a genuine concern of the local planning authority, I've no doubt that they can impose a condition that says the works of the golf club shall be completed prior to the occupation of X house on the residential development site. So I don't think it's necessary for the reasons I've already given, because there will be proceeds of sale and there will be obligations upon the club. And I think it's almost in a real world scenario inconceivable that the club wouldn't improve the building and implement that permission. But as I've said, if it is a concern, I've no doubt that it can be dealt with by condition. Doesn't have to be part of the obligation.
Thank you, Mr. Barrett. Okay, well, moving on then to the Widnes Golf Club works. My understanding, I think we've already touched on this, is that it requires the appellant to carry out the works as soon as reasonably practicable and acts as a restriction on occupation until they've been carried out. Ms. Ty, I understand this is again help to secure the equality of provision point that we've already touched on, and I don't think there's any significant difference between that and the first one in terms of if the issue that we just discussed on the surplus to requirement point, it would fall away if I were to find in favour of the appellant on that specific point, because it's designed to go towards section 99B rather than anything else. I've seen in the compliance statement how you consider it meets the tests. One of the questions I have is the phasing, why it's split into two phases.
I think it's just genuine about timescales for doing the works. It's likely that that's how they will be phased. And I think in discussions with the golf club about the practicalities and logistics of actually carrying out the works, this was what they requested in terms of the second lot of works are more about the kind of the wider golf course improvements rather than the clubhouse itself. Phase one is very much the clubhouse, and then I think the main concern was about the irrigation system and getting all the consents and everything that was needed in order to make sure that could be put in. They just needed a little bit longer. I mean, obviously the kind of the occupation restrictions are very much kind of fallback, long stop dates in any event. There is a timetable that has these works carried out, but they're just the kind of the back end of the works.
So why 125 dwellings? Presumably, my understanding of this is that 125 dwellings, which is more than half of the residential element of the site, could be built before any improvements to Widnes Golf Club are made. Is that a fair understanding?
Well, I think the reality is that it would never work in that way. You would, from Amwell as a house builder's perspective, they would never wait until the 126th house was ready to be occupied for the golf club to make a start on these works. The reality is that both those first phases will be done in parallel, and those works to the golf club to provide the new golf club house will be going on at the same time as the initial phase of housing is being built. It wasn't arbitrary. It was based on, these are construction time scales, but with a little bit of a buffer built in to cater for any contingencies or anything that happened. So it wasn't an exact science, but it was based on some degree of science in terms of likely construction timetables. And it certainly wasn't the case that the golf club works would wait to start until, say 50 or 60 houses have been built. They will be done in parallel.
So how would this link in with, I don't know if you were around with our discussion on condition 3 earlier, which was phasing.
Yeah.
There's a phasing condition included, which needs to show continuity of golfing provision. And I suppose one of the areas I'd like to explore is whether this, or how this would link in with that.
I mean, I think it only links in the sense that whatever phasing timetable is approved at the point at which it's approved under that condition will need to take into account the need for these works to happen. So I don't see that as being a direct link, but obviously this the need to have those works completed by 125 dwellings will need to be taken into account when that phasing plan is drawn up. But I certainly don't think the obligation does away with the need for that phasing condition to be in as part of the conditions, because this is just one bit of the phasing.
You indicated a moment ago that it's unlikely that the occupier, that the developer would wait this long for 125 dwellings, and so presumably if they have a phasing plan that shows these dwellings, the golf club works being carried out quite early on, that wouldn't impact, these two things wouldn't.
No, this is just it is just a fallback. There's no requirement not to complete them before 125 dwellings. Yeah. It's just a long stop.
Thank you. That's useful. Mr. Hunter, do you have anything you'd like to raise in relation to this particular obligation?
No, sir. Thank you.
And Mr. Barrett? Anything?
Thank you, sir. I've got nothing to add to what Ms. Ty has said.
Thank you. I'm carrying our previous discussion on the surplus to requirement point forward, as I mentioned at the start, in that if I would find in favour of the appellant on the surplus to requirement point, then the same issues that we discussed previously would apply, that these obligations would remain because of the lack of a blue pencil clause, but wouldn't necessarily need to be given any weight in my decision. Moving on then to the next one, which is the works to Blundell's Hill. Ms. Ty, thank you very much for pointing out to me earlier that it's not contingent upon the acquisition of that as okay. Well.
Yeah, earlier drafts were, so that's why I know that, because it was deliberately done.
Thank you. So my understanding of this is that they are required to, two things need to happen, the grant of planning permission and the acquisition of the golf club. The grant of planning permission and the acquisition of the residential development land. And at that point, the club then obtains control of Blundell's Hill in accordance with the share purchase agreement, which I don't have details of, so I don't know how that operates, but we'll put that to one side for a moment and not sure whether I need to at this point. Following the club obtaining that, then they can permit access at reasonable times, and they use reasonable endeavours or all reasonable endeavours to submit a planning obligation within 9 months of commencement of development. And then, subject to those consents being obtained, they have to carry out and complete the phase 1 and then the phase 2, and there's a similar restriction on occupation, slightly higher levels, but to the previous one that we discussed. I suppose the thing that strikes me on our previous discussion, Ms. Ty, is what happens in the event that for whatever reason, the developer, the golf club becomes unable to either purchase or obtain control of Blundell's Hill.
I think that the reality of that is that we can't occupy any more than 150 dwellings unless we could in some way get those works carried out by the current owners and controllers of Blundell's Hill Golf Club. I think the reality, that's why I know they're not before you, but why the contractual provisions that sit behind all of this, from Amwell as the house builder's perspective, there are lots of contingencies and everything built in to those arrangements to ensure that this will happen. If we get planning permission, everything else does follow on from that. But appreciate that that's not something that's before the inquiry.
Mr. Barrett, on that point, in view of the fact that none of that information is before me, I'm not going to ask you why it's not before me, but what I am wondering is how I can be certain that these obligations can actually be implemented.
It's for that reason, sir, that there's the absolute backstop position of 150 dwellings, because the degree of assuredness and confidence that those entering into the UU have that they can deliver this is obviously contingent on their recognition that if they do not deliver, then they will be unable to complete the development beyond 150 units. I don't think it's a necessary requirement that you have to have a degree of assuredness to the nth degree that this is capable of being brought to fruition. So I think you're entitled to take a view that if for whatever reason it doesn't, then you look at it from a legal point of view and say, well, that's the price that will be paid.
But in that situation, would I not be then agreeing to grant consent for 150 dwellings without these works without any certainty that these works would be carried out? Because my understanding, Mr. Barrett, and just so you understand where I'm coming from, it's not necessarily about me satisfying myself to the nth degree. I think it's more about me understanding how this obligation is acceptable in planning terms, or makes the development acceptable in planning terms under the Section 99B regime. So the appellant, if I were to find against the appellant on the surplus to requirements argument, and then I look at the equality of provision arguments being put forward, and I were to find, well, in this circumstance, taking into account these suggested obligations, then I can satisfy myself that equality of provision is being met, or the requirements around equality of provision is being met. When I look at this obligation, I do, I will suggest anyway, need a certain degree of certainty that these could be implemented, and that's the position that I'm coming from. Not necessarily trying to cross off, dot every I or cross every T, but more understanding how I get certainty and what weight I can afford to these obligations in that part of my consideration.
So I was just going to say, there are some details in the letter from the golf club, which is AD 047 in the core documents list. And that does give some details of the back-to-back share purchase agreement that's in place.
Yes, I have seen that. I bring that up. Are there any particular parts you wanted to direct my attention to?
It's just, yeah, if it under the, well, I suppose the third and fourth bullet points are relevant. The third more relevant to what we've just been talking about with the Widnes Golf Club works, but that refers to the fact there's a retention from the sale monies until the clubhouse works are carried out. And then the fourth bullet point deals with the share purchase agreement. So it confirms that that's back to back, that happens. If the residential development sale happens, then that share purchase agreement is triggered, and under that there is a transfer of all the share capital of Blundell's Hill Golf Club Limited.
Is this share purchase agreement registered as an option at the land registry against the title?
I don't think it is. So.
Mr. Barrow, before I invite Mr. Hunter, was there anything else that you wanted to come back on there that I think you were?
No, sir. I think you have to come to a judgment as to whether the information before you gives you sufficient comfort and certainty that what the obligation sets out will be provided. So in my submission, one, by reference to the letter, and two, to some extent, just simply by reference to the parties to the agreement and the obligations legally placed upon them. You can have that degree of assurance that the delivery of Blundell's Hill and the works at Blundell Hill and the control over Blundell's Hill will be secured. That has always been a primary purpose of my client's case that's been placed before the local planning authority now for a period that's really calculable in years.
Thank you, Mr. Barrett. Mr. Hunter, did you want to say anything on this obligation?
I think so. I think all I would want to say, the points you've already made about this, I would be repeating, but so your concern, it would have, if you had not raised it, was the one that I would have raised about, well, the point here is not to take everything on faith. The point here is to be confident and sure that if permission is granted on the basis of equivalent provision, that there will be equivalent provision. And the point you raised, I think, shows that you can't be sure of that. It might be likely to happen, but it's not guaranteed by the undertaking. Thank you, sir. That's it. So I don't think I have anything else.
Thank you, Mr. Hunter. Mr. Barrett, is there anything you want to come back with back on any of those points?
So is it only to say that the share purchase agreement isn't registered against the title because it is done. It's not an option. It's not a land transfer. Oh. It is very much done as a company share purchase agreement. So they purchase the entire shares in the company that owns the land rather than the land transferring.
So I've got nothing to add.
Okay, I see. Yes, I see. Thank you. Okay, I think that covers those first three obligations. The next one I think we could probably deal with quite quickly. It's the open space management plan. It's for approval and implementation, including in terms of public access. My understanding it restricts occupation until a plan is submitted for approval. I suppose what's its purpose, Ms. Ty? What's it seeking to achieve, and how does it meet the tests?
It's seeking to achieve just something that goes beyond the condition. So I think the first two parts until you come to the second half of the last obligation, simply reflect what's in the draft conditions. But the point about ensuring public access is something that isn't in the condition. So to ensure that public access is provided at all times to the areas that are shown in that management plan. So that's the main purpose of including it.
I think that answers my next question. Actually, my reading of the condition was that it focused quite a lot on habitat for biodiversity purposes, whereas this obligation focuses more on management and maintenance of areas of public open space.
Yes, correct.
And can I ask, which of these two deals with, or possibly both, deals with the proposed footpath link?
I think it would be that would be shown in the open space management plan as an area for public access.
And the maintenance of that would be,
if you look
at the obligation.
If you look at the open space management plan definition, it's for provision and future maintenance of open space areas and the footpaths to be provided through the WGC retained land and the residential development site.
Thank you. My next question, Ms. Ty, is on the specifics of the wording. I can see here it says, prior to first occupation of the development, to submit to the council the open space management plan for approval, and then following its approval to implement it. What happens if it's not approved, but if it were to be submitted but not approved?
Then you'd have to turn to the condition. There's no restriction. There's nothing that says can't occupy until it's approved.
Because if we look at the next one, the sort of more usual wording would be that it would be submitted and approved in writing, and then that ties the approval.
That wasn't deliberate in any way. That the council had plenty of opportunity to comment on all these obligations.
And I'm wondering where that leaves us in the sense that, from my perspective, in considering this obligation, how we deal with that. Gentlemen, I'm open to suggestions here. Mr. Hunter, before I do that, I should probably invite you to comment. I've assumed that this isn't particularly a contentious one for the council, but I may be mistaken.
No, I'm wondering whether this is one for Mr. Plant, because this is a planning issue, really.
It could. I was just going to say it could be a condition could be added to support it if that was.
Presumably, if it was dealt with by way of condition, that would be a solution, because then I think PPG would say that if it can be dealt with by way of a solution, it would be better dealt with by way of a condition.
Yeah.
And then, but there's no blue pencil, so I couldn't strike this one out anyway.
I don't think that would matter, sir. It would just mean it was enforceable through the condition, and this obligation would remain.
Yes.
So there would still be a plan that was approved pursuant to the condition, and under this obligation, we'd be obliged to comply with that plan.
And if I'm right, Ms. Tower, the wording of the condition could be virtually as set out here, but with the additional wording that we just discussed added in to make sure that it was approved.
Not to occupy until approved. I think that's the wording that you would add to the 106 if it was, so it would be a kind of no occupation condition.
Yes. I don't know if Mr. Plant and Mr. Dorber are present now, and if that's something that you could perhaps consider dealing with as part of the discussion on conditions that you're currently having.
Of course, I've noted that additional condition down, sir.
Thank you. That's great. Mr. Barrett, did you have anything on that one?
No, sir, I hadn't spotted that either, so apologies for that. But it seems to me quite easily dealt with by way of a condition of the type discussed. I don't see anything wrong in principle with doing that.
Thank you. And Mr. Hunter?
No, so I've got nothing further to add on that.
I think in that case we can move on to affordable housing. I'm mindful that we've been going for some time, but I think we can probably wrap this up before we take a break. I'm aware that there are a number of different ways of securing affordable housing, but most or many Section 106 agreements contain much more detailed provisions than the one we've got here. So I think my first question is, why is the affordable housing obligation here so brief?
Because that's what the council asked for, sir. So we proposed it as a condition. So I think in effect, the wording that is in here is much more usual to see as a condition. And we asked for it to be a condition, but the council wanted it to be in the 106, and this was their proposed wording.
Sandra, I'm going to put you on the spot a bit here now, because you've only looked at it this morning, presumably, or you're only familiar with it this morning. So I suppose where I'm coming from on it is that while I accept that there's no obligation in national policy for it to be an obligation, I do need some sort of certainty. Now, it's drafted very much in the way that I would expect a condition to be drafted. But the PPG makes clear that those kind of conditions on affordable housing should only be used in exceptional circumstances. Now, my intention, Ms. Dye, had been to ask you what these exceptional circumstances are. So presumably, if you were proposing it as a condition originally, is it fair to say that the appellant's position is that there are exceptional circumstances?
I'd probably have to defer to Barton Wilmore on that point, to be honest. I mean, I think the reality is that where I've dealt with affordable housing secured by condition, a Section 106 agreement then ultimately gets entered into in order to discharge that condition.
Yeah.
And I would see the same happening here, that actually it would need a supplemental deed at some point to deal with the detail of the affordable housing in order to get the scheme signed off under this 106. That's the reality and of the practicalities of delivering affordable housing when it comes to delivery. But I suppose we were slightly in the council's hands on this.
Mr. Plant or Mr. Hunter, can you shed some light onto the approach, why this approach is being advocated by the council?
Sir, I think similar clauses have been used in the past, but again, in relation to the condition under other appeals and inspectors, we've come across that conditions can only be used in those exceptional circumstances, which is why we'd ask for it to be included in the agreement.
So I can't add anything on why it's drafted like this, but I think so. So I think I tend to agree with Miss Ty that whether it's, I mean, it doesn't strictly require another Section 106, but in practice that'll be how it's done. But it effectively defers it. It's like, so as effective or like a condition, it's sort of a and whilst it may not be the conventional way to do it in a Section 106, I was looking at it and I was just wondering whether or not there is anything problematic in it, but I don't think there is, because it's effectively an obligation to enter into an affordable housing obligation. So it's just, I suppose what it means is, so is you don't know when you make your decision what the final scheme will be. That's all. That will be.
Is it fair to say it's an agreement to agree that's been entered into here?
Almost, yes.
Almost, yes.
It does require something, but it is, yeah, it's close. But yeah.
Mr. Barrett?
Wishing to dissent too much from what Mr. Hunter said, I think it's got a bit more about it in terms of enforceability than that, because it's a pure pre-commencement condition. We can't do anything on site until we have a scheme agreed with the council that provides there's the framework for what then will go in, and I'm sure Ms Tighe is right, there will be a planning obligation that will have much more greater particularity here, but the framework is there. There's 25% have to be affordable. We have to identify the number, type and tenure and location. So if it's going to be pepper potted around the site, all that is provided for in the scheme that has to be submitted, which then has to be approved by the council. So there is an appropriate degree of control over not only the level which is specified in the obligation, but the type, tenure and location all have to be provided for at presumably some sort of time following a grant of planning permission, which all this will have to be sorted out.
Yes, I mean, in the sense, Mr. Barrett, that it's very similar to a negatively worded condition, almost identical to a negatively worded condition.
It is a negatively worded condition, but it
serves the same purpose. What I suppose I'd like to understand is that if it were a negatively worded condition, I would be asking for exceptional circumstances. The fact that it's been moved into a planning obligation, does that mean that I don't need exceptional circumstances, or do I still need to satisfy myself under the should the PPG advice essentially be carried over in these circumstances to this obligation? And if so, what are those exceptional circumstances?
Well, I'm not putting, unless Mr. Dorber is going to correct me, I'm not putting forward any exceptional circumstances, sir, because I'm not sure what the discussions were between the council and my clients at the time. There was this discussion, but what is clear is that a planning obligation is different from a condition, because a condition can be then the subject matter of a Section 73 application to vary it. This, of course, is a binding planning obligation with all the rights and responsibilities and enforceability that the council will have for a period of 5 years from the following of the entry into it. So legally, there is a difference between the two, which I think is the reason why the PPG advises in the way that it does. And of course, in those circumstances, you would draw a distinction between a condition which requires exceptional circumstances and an obligation which doesn't, because once this obligation bites, it prevents my clients from making an application under Section 73 to discharge the condition. That's an opportunity that's simply not available to us in a planning obligation.
Okay, so if I understand correctly, Mr. Barrett, the appellant's position is that in these circumstances, for the purposes of this obligation, exceptional circumstances isn't something I need to be considering.
No, I don't believe you do, sir.
Thank you. And Mr. Hunter?
So I don't think you can, because it's the main difference is you decide whether to impose a condition. This obligation is being executed. So I think it's. Sorry, I can't remember. Has it been executed? I can't remember now. So whether it has been, but it will be. But it has been executed. So it's not. It's just a question of whether or not you take it into account and give it weight.
Yeah, I certainly agree with that.
Yeah. Okay. Thank you very much. That's something I'll have to give some further thought to. Following the close of the inquiry. Thank you very much. I think that's all of the issues that I have. Does anyone else wish to raise any issues in relation to the obligations? Anything, Mr. Hunter?
Oh, thank you, sir.
Ms. Tile, Mr. Barrett?
No, thank you, sir.
No, thank you. That's cleared up a few of the queries that I had. So thank you all very much for participating in that, and thank you for your time today, Ms. Tighe. I know you attended on the last day of the inquiry as well, and you had to hang around all day. So I apologise that we had to have you call back again today, but thank you very much. You can turn your camera off now and switch off your microphone. Thank you. Gentlemen, it's 12 o'clock and we're not actually ahead of time as far as I can tell at all. So I'm going to suggest that we take a short break for lunch. I'm entirely happy to take the hour break that we've got planned, or we can take a shorter break if you prefer and come back after about 30 minutes, 45 minutes if you wish, and your closings then. So entirely in your hands.
So for my part, I think unless Mr. Barrett thinks otherwise, I was thinking a short lunch break and come back, or unless it causes any inconvenience to anyone.
No, I would agree. So if everyone can accommodate a 30-minute lunch break, that I think would be sensible.
I'm happy with 30 minutes. In that case, I think I have received written closings from the appellant this morning. I'm not sure, Mr. Hunter, I've received written closings from yourself yet.
So I'll arrange that in the next few minutes.
If you could send them over just so I have an opportunity to print them out in the break, that would be useful. It's now 12 o'clock. We'll adjourn until 12:30 and then we'll come back to your closings. Thank you very much. Cheers. We're now adjourned. Welcome back, everyone. It's now 12:31 and the inquiry is resumed. Sorry, can I just check we have Mr. Barrett?
Yes, sir, I'm here.
Hello, Mr. Barrett. Next on the programme is closing statements. Gentlemen, do you have anything before we move straight on?
No, sir, thank you.
No, not from me, sir. Thank you.
Thank you very much. In that case, Mr. Hunter, would you like to make a closing statement on behalf of the council? Mr. Hunter, before you do, I've got the third version of it. I'm assuming that's correct.
I'm sorry, sir. This is I thought I'd saved it to PDF, and when I read it through, it was missing some amendments. So the last version you got, which was a Word document, is the correct one, I think. Hopefully,
that's the one I printed out. If not, if I see any changes, I'll let you know.
Thank you, sir.
Thank you.
They're not huge anyway. So. So the appellant's case was originally that permission should be granted on the basis that policies G6 and G10 of the UDP, which in its view were the most important policies for determining the application or appeal, were both out of date, thus triggering the tilted balance in MPPF paragraph 11D. And because, again, in its view, the adverse effects of granting permission wouldn't significantly and demonstrably outweigh the benefits. That case, however, became immediately obsolete midway through the inquiry following the adoption of the new local plan. At first, it wasn't entirely clear how the appellants intended to reformulate their case. However, in cross-examination, Mr. Mitchell confirmed that their revised case is that permission should be granted on the basis, somewhat surprisingly, that the tilted balance is still engaged as policy HE6 of the new local plan is out of date, or alternatively, that the proposal is in accordance with the development plan. Mr. Mitchell agreed, however, that if both these arguments failed, the appeal would have to be dismissed because he accepted that if you were to conclude that the proposal is contrary to the plan and the plan is up to date, he wasn't suggesting that there are any other material considerations of sufficient weight to justify departing from it. As a result, before I turn to the main issues in development plan compliance in light of them, I propose to deal first with the suggestion that the tilted balance is engaged on the basis that policy HE6 is out of date. With respect to Mr. Mitchell, this argument is, to say the least, a somewhat ambitious and adventurous one, given that the plan was barely a day old when he first advanced it, and policy HE6 had been examined and found to be sound less than a month earlier by the local plan examiners. It's also without any substantive merit. The essential point made by Mr. Mitchell was that the evidence base for the policy was inadequate because there was no specific evidence on golfing needs. But there didn't need to be, although Mr. Mitchell was quite right in saying that NPPF paragraph 98 refers to the need for planning policies to be based on robust and up-to-date assessments of need for open space, sport and recreation facilities. What it doesn't say, first of all, is what kinds of sport or recreation they need to cover. That's left as a matter of judgment for decision makers. It would be impossible in practice to prepare assessments for every single kind of sport, and the NPPF doesn't demand it. Secondly, what the NPPF also doesn't say is that if there has been no specific assessment of the need for facilities for a particular sport, then a local planning authority isn't entitled to adopt a policy, that should read, which seeks to protect existing facilities in relation to that sport. On the contrary, as NPPF paragraph 99 makes clear, the government's policy is that sports facilities should be protected unless it can be established, amongst other things, that the facility in question is surplus to requirements. Thus, the way the NPPF's own policy on the loss of sports, land and facilities is structured shows that far from requiring local planning authorities to have their own, that should read, evidence of need for a facility in order to justify refusing a development that would result in its loss, it's the other way around. There is a presumption, in effect, that development which would result in such loss should be refused unless the applicant can show that it's not needed. The local plan inspectors clearly understood this, and I respectfully submit they were obviously right. So then, turning to the main issues. Firstly, whether the site offers an acceptable location for the proposed development having regard to its current use as a golf course. I set out then NPPF paragraph 99, and I will read it. Well, so I'm not sure there are any members of the public, but in case there are, I'll read it out. The existing open space, sports and recreational buildings and land, including playing fields, shouldn't be built on unless A, an assessment has been undertaken which has clearly shown the open space, buildings or land to be surplus to requirements, or B, the loss resulting from the proposed development will be replaced by equivalent or better provision in terms of quantity and quality in a suitable location, or C, the development is for alternative sports and recreational provision, the benefits of which clearly outweigh the loss of the current or former use. Similarly, policy HE6 of the local plan provides the council will not permit development likely to result in an unacceptable loss of existing sport or recreation facilities for non-recreation purposes unless it can be demonstrated A, that development is ancillary to the sport and recreation use and doesn't reduce the overall recreation function of the site. B, that replacement sport and recreation provision of at least the same or better quantity and quality and in a suitable location to meet the needs of existing sport and recreation facilities. Or C, that the site or stroke facility is surplus to recreational requirements and isn't capable of helping to meet any of Halton's identified needs. The proposed development would result in the loss of approximately half the current golf course and half the number of holes to housing development. Therefore, in order for the appeal site to be an acceptable location in principle for the proposed development, the appellant must show that at least one of the defined exceptions applies. The housing proposed is self-evidently not alternative sports and recreational provision, and therefore exception C in NPPF paragraph 99 cannot apply. So can I just add in parenthesis, what one might say is that the replacement of the rest of the 18-hole golf course on the northern part of the site is alternative sports and recreational provision. but one certainly can't say that in relation to the southern part of the site. Equally self-evidently, it's not ancillary to the sport and recreation use, and it will reduce the overall recreation function of the site. Therefore, nor can exception A in policy HE6 apply. Accordingly, the appellant must either show that the land which will be lost is, quote, surplus to requirements, end quote, open quote, or surplus to recreational requirements and isn't capable of meeting any of Halton's identified needs, end quote, or that it would be, open quote, replaced by equivalent or better provision in terms of quantity and quality in a suitable location, end quote, or open quote, that it's for replacement sport and recreation provision of at least the same or better quantity and quality and in a suitable location to meet the needs of existing sport and recreation facilities. In relation to the former, so that's a surplus to requirements or surplus to recreational requirements exception, Mr. Wright contended that the KKP needs assessment demonstrates that, open quote, the needs of golfers in the catchment area can continue to be met regardless of the proposed development and the loss of 9 holes, end quote, and that it can, open quote, therefore be concluded that the provision is surplus to requirements. However, nowhere in the KKP report is such a conclusion expressed, which is most odd if that was what it was intended to show. And furthermore, the first 2 reasons Mr. Wright relied on as establishing that conclusion, in fact, establish no such thing. The first reason he gives, namely with 327 current members, membership at Widnes Golf Club is at a level that could be accommodated and supported at a 9-hole facility without any capacity issues, clearly doesn't show that the needs of all 327, let alone any others, would be met if the course were reduced to 9 holes. Unless one assumes, contrary to the known facts, see the February 2020 survey of the membership at page 45 of the KKP report, that none have any need or desire to play 18 holes. Similarly, the second reason, the fact that membership is below the national average, despite the national trend, quote, open quote, national trend of increasing participation, especially those experienced by clubs following the COVID-19 pandemic and the lifting of various restrictions, end quote, merely shows that for some reason or other, the club is finding it unusually difficult to retain and attract members. As Mr. Smith said, it's inconceivable that the 18% fall in the club's membership between 2019 and 2021 could be due to the issues the club identifies, such as being a tight site, the health and safety issues it says it has, and the condition of the facilities. And in reality, it's far more likely to be due to the sort of factors he, i.e. Mr. Smith, lists. For example, the club's reluctance to invest given its future plans, uncertainty over its future, lack of drive by the club itself, or a given-up mindset. The third reason Mr. Wright gave, i.e. the proposal to acquire Blundell's Hill, is also flawed, because merely acquiring Blundell's Hill won't create any new capacity. Furthermore, given that Blundell's Hill already had 482 members in 2018, and 65%, that's a total figure, or in other words, 213 of the club's members said that they would want to use it, i.e. Blundell's Hill, if the proposals go ahead. There is a real question whether it has sufficient capacity to absorb such an increase. This hasn't been assessed by KKP. Indeed, Mr. Wright couldn't even confirm how many members Blundell Hill currently has, or whether, as appears likely, they have increased from 482 in 2018. This is just one illustration of a more fundamental flaw in Mr. Wright's reasoning, namely the assumption that provided that other clubs are continuing to accept members, golfers' needs will be met regardless of Widnes Golf Club. As Mr. Smith explained, that's a fallacy. Clubs, by and large, are always, and I use that in a loose sense. I accept that at some point clubs will say no, but their threshold, I'm suggesting, is quite high. They're always willing to accept new members, since this is how they generate revenue. However, after a certain point, this inevitably impacts on quality and availability, especially at peak times, which, as Sport England's guidance makes clear, are crucial considerations in assessing needs. In the absence of any proper assessment of quality and availability at Blundell's Hill and the other clubs, in order to determine what capacity they have to take on new members without having any undue adverse effect on those matters, it is impossible to say that WGC, so Widnes golf course is no longer required as an 18-hole course. It is akin to assuming in the context of retail development that there is no need for a particular supermarket because if it closed, its customers would still be able to make their purchases elsewhere. The lack of evidence in KKP's report to demonstrate, consistently with Sport England's guidance, that the existing course is surplus to requirements was also one of the key issues raised by Sport England in their objections. Moreover, as Mr. Smith explained in his written and oral evidence, the application of the industry standard benchmark of one course per 20 to 25,000 head of population tends to show just the opposite, i.e. that there's a significant deficit given that the ratio within the 20-minute drive time catchment is 1 to 35,500. Other indicators also point the same way. For example, the fact that membership fees in this area are for the most part significantly above the national average, despite its socio-economic profile. In relation to the exception for replacement provision, the appellant's case is deeply misconceived. Whilst Mr. Wright and Mr. Ritchell are correct to say that in some cases at least, there could be replacement provision of equivalent or better quality and quantity, even if the replacement provision occupies a smaller area than that which is lost. For example, if one builds on a number of full-side football pitches, but replaces them with much better five-a-side pitches, which is a greater need, where their argument falls down. Read that again. Whilst they're correct to say that there could be, in some cases at least, replacement provision of equivalent or better quality and quantity, even if the replacement provision occupies a smaller area than that which is lost, where their argument falls down, nevertheless, is that there has to be at least something provided to replace that which is lost. And that was actually, as I put in the footnote, that's how it was put in questions by Mr. Barrett. Here there is nothing. The part of the current 18-hole course which is to be lost to the housing is not going to be replaced at all anywhere by anything. Blundell's Hill is an existing club and there is no new facility proposed on it. The works proposed to it are minor, will not increase capacity and can in no way be considered equivalent provision in quantity and that should be quantity and quality to what is being lost. Nor can the provision of a new 9-hole course on the north of the site be regarded as replacing the loss of land on the south, not only because there's already a course there, but also because the 9-hole course is, if anything, replacing the remainder of an 18-hole, replacing the remainder of the 18-hole course on the northern part of the site. And so it will be double counting to treat it also as replacing the southern part of the site, which is being lost. Furthermore, notwithstanding Mr. Mitchell and Mr. Wright's attempts to enlist the Bicester decision as support for the contrary argument, it isn't of any assistance to them, indeed, just the opposite. In that case, unlike this one, the proposal involved not only the reconfiguration of the remaining part of the course as a 9-hole course, but also an upgraded driving range and a new, I should read and instead of but, a new 9-hole par 3 academy course and a short game practice area. And it was the entire package, not just the 9-hole course, which the inspector held to satisfy the exception in MPPF paragraph 99B. In any event, even if the inspector had found the exception to be made out solely on the basis of the 9-hole course, the decision would still not assist the appellants because one of the key factors which led the inspector to his conclusion was that, open quote, apart from 1 or 2 holes, end quote, all of the new holes allowed for a second tee to be positioned, open quote, in such a way as to produce a materially different direction of drive and to introduce additional hazards through new planting and or sand/water features. Whereas in this case, as Mr. Wright accepted, the situation is reversed. Only 1 or 2 of the holes on the proposed 9-hole course will allow for this, and so the overall experience of playing the course twice would not allow for the variety described by the inspector in the Bicester decision. Sorry. In addition, in the case of one hole, hole 9 or 10, if it's played the other way, there is the potential for conflict and health and safety issues, given that it will involve playing towards the green on hole 1, on which others may already be playing. On top of this, there is good reason to doubt whether the proposed 9-hole course would itself be viable, As Mr. Smith explained, standalone 9-hole golf clubs without good practice golf academy facilities on site struggle with financial viability issues. The appellants have presented no evidence to gainsay this, and Mr. Wright accepted that, unlike Mr. Smith, he didn't have any material experience in terms of dealing with golf club finances, and it's unclear on what basis they arrived at any different conclusion, to the extent that they really considered the matter at all. Moreover, such problems are only likely to be exacerbated when the proposed new course on the nearby St Michael's site is operational, as the two will be directly competing. And again, as per Mr. Smith, St Michael's driving range is likely to make it more attractive and successful. For all these reasons, the appellants cannot demonstrate that any of the exceptions in MPPF paragraph 99 or policy HE6 are made out, and as a result, it is clear that the proposed development is unacceptable in principle in this location as a matter of both national and development plan policy. Second issue, the effect of the proposed development on designated green space. So the new policies map only shows the site as a golf course and not as any other green space infrastructure typology. The objection isn't pursued further. So we had a lot of discussion about HE4 last time, but the result of it was that Mr. Eaton agreed it wasn't applicable. 3, the effect of the proposed development on highway safety. The sole remaining point of dispute in relation to highway safety relates to the eastern access. The eastern access is proposed to be a priority control junction with Coast Island. It's situated directly opposite the access to the former St Raphael's Church and Presbytery, which is now an 18-bed managed HMO with 10 full-time equivalent employees. The proposed layout for the site shows the new junction directly opposite the existing access, resulting in conflicting giveways for opposing vehicles. Although Mr. Woolliscroft for the appellants contended that due to the low number of vehicles turning right into the former church access, the open quote conflict would remain minimal, end quote, it would still be unsafe, and as such, contrary to MPPF paragraph 110B and policy C1 of the local plan. Mr. Woolliscroft also suggested that it would be possible to introduce a stagger to reduce the conflict along the lines of that proposed for the western access. However, as Mr. Peake explained, the proposed adjustment isn't significant enough in this case to eliminate the risk of conflict, and it would appear there's little scope for further adjustments in that location without revising the layout more fundamentally. 4, the effect of the proposed development on flood risk and drainage. It's common ground that as the proposed development includes dwellings within the floodplain of Moss Brook, where there's a risk of flooding from events with an equal or greater than 1% annual exceedance probability, the appellant must satisfy both the sequential and exception tests. In relation to the sequential test, the LPA has not taken issue, although it could have, with the possibility of the housing being located on another site. However, what it does say is that there's no evidence before the inquiry to demonstrate it would not have been possible to relocate the affected housing elsewhere within the site. Mr. Aldridge's evidence, including Barton Wilmer's note, only provided justification for locating the housing generally in the southern half of the site. It didn't explain or justify why the particular dwellings affected had to be located in the area of greatest flood risk, that should read. Furthermore, neither Mr. Aldridge nor Mr. Mitchell suggested that there had been any attempt to devise another layout to see if this could be achieved. And prima facie, given the small number of affected dwellings and the size of the site, it would seem very unlikely that it could not. However, even if the sequential test were passed, the proposal would still fail the exception test. MPPF paragraph 159 makes clear that development in areas at risk of flooding should only occur when it's necessary. And furthermore, MPPF paragraph 164A explains that in order to pass the exception test, a development must provide, open quote, wider sustainability benefits to the community which outweigh the flood risk. In relation to necessity, there is clearly no need for the overall housing scheme proposed as part of this application. It is not required as part of the LPA's 5-year supply, and nor is it required in order for the LPA to deliver its housing requirement over the longer term, in contrast to the position in the Nantwich appeal. On the contrary, as the local plan inspectors noted in their final report, there is actually an oversupply of 6.8 years. Furthermore, far from achieving any other wider sustainability benefits for the community, it would result in the loss of land use for sports and recreation, which, as I've noted, isn't surplus to requirements and which won't be replaced by equal or better provision in terms of quantity and quality, as well as a number of other significant adverse effects, for example, on highway safety, trees, and the landscape. It is not even necessary in order to fund the proposed works on the golf course or the facilities at the site. Although the price paid hasn't been relieved, it's clear that although the price paid hasn't been revealed, it is clear that it far exceeds what may be required for those works, since it's also being used to fund the purchase of Blundell's Hill, and the unilateral undertaking anticipates that there may still be money left over after that. Accordingly, the proposed development is also contrary to National and Development Plan policy on flood risk. I take 5 and 6 trees, the effect on trees and character and appearance of the area together. In terms of arboriculture, as Mr. Cocking explained, the proposed development would destroy or detrimentally impact around 60% of the vegetation on site, including around half the trees protected by TPO within the area of the proposed development. There will be a major loss of amenity locally, particularly due to the fact that much of the tree cover on the frontage along Liverpool Road will be broken up. There's also significant risk of further loss or harm due to inadequate protection of root areas and the proximity of some of the proposed houses. The appellant's assessment, that should read, of the significance of the loss is understated due to, amongst other things, a large number of errors regarding, in particular, the height of trees. As Ms. Quayle explained, the proposal would also cause significant harm to the landscape and the character and appearance of the area. The breaking up of the Liverpool Road frontage, together with the introduction of housing into the view, will, I think she described the words in the Ms. Quayle used, filtered views, will result in significant harm to views and a substantial loss of amenity for those living in the area. The development on the southern part of the site would also have major adverse impact on the site itself, reducing to major moderate at year 15 due to the loss of key features, including the open grassland of the golf course and substantial parts of the tree cover, and the introduction of the housing itself and related works. There'd also be major adverse effects on the Ballarditton Parkland landscape character area due to the extensive loss of one of its key characteristics, that is 11 hectares of grassland and mature tree cover, as well as the impact of earthworks. The effect would be profound, given that the area affected forms between 10 and 15% of the whole landscape character area. And as a result, the proposal is also contrary to local plan policies CSR 20, HE1, HE5, GR1, GR2, and NPPF paragraph 174B. So for all these reasons, the proposed development is in clear and substantial conflict with the development plan and national policy, both in principle and in terms of its effects. As the plan is up to date, and the appellants don't suggest that there are any other material considerations to justify departing from it, the planning authority respectfully submits that the appeal should be dismissed. So those are my submissions, unless I can assist you further.
Thank you very much, Mr. Hunter. Great. Mr. Barrett, would you like to make a closing statement on behalf of the appellants?
Yes, I would, sir. I understand from what you said earlier, so you've already got a copy of mine. I've sent by email. If Mr. Hunter hasn't received it, will he just indicate now, and I'll send him another copy? He should have been provided with a copy already.
It's been received. Thank you very much, Mr. Barrett. Thank you.
So I begin with an introduction that the opening that I provided at the start of the inquiry now some time ago, I adopt without further repetition. And I'm going to follow the main issues that were discussed in that opening, and following on from the CMC. The only departure will be that issue Z in relation to trees, and F in relation to landscape I'm going to address as one issue. I note that Mr. Hunter has done the same. So the first issue is whether the site offers an acceptable location for the proposed development, having regard to its current use as a golf course, And there are two elements to the proposal. Firstly, the residential development, and secondly, the reconfiguration of the existing golf course and improvements to the clubhouse and ancillary features. There can be no doubt that the site offers an acceptable location for the development comprised of the reconfigured golf course, clubhouse and ancillary infrastructure. The controversial issue relates only to the residential development. The acceptability or otherwise of the appeal site being an acceptable location for the residential component of the development turns on the continued needs associated with golfing provision. This in turn is to be addressed in the context of the evidence provided to the inquiry concerning the need for golf provision, and I therefore turn to the needs assessment. There have been two needs assessment prepared by Knight, Kavanagh and Page the first was submitted with the original application in 2019 and has been updated, and it's that updated 2021 needs assessment that informs the current assessment. The needs assessment produced a detailed demographic analysis of the catchment population, age, family structure, future population were all considered, and the purpose of the report was to develop an understanding of the supply and demand for golf provision in the locality of the golf club. A catchment area covering a 28-minute drive time of the golf club has been established and agreed as part of the Statement of Common Ground. The extent of the 20-minute drive time is shown on figure 3.1. As a consequence, a count of golf courses outside of Halton were considered. Existing golf facilities in the catchment of the golf course is shown on table 3.2. There are currently 13 standard 18-hole golf courses, plus the 18-hole golf course at the club itself within the 20-minute drive time catchment. There are no 9-hole courses. Plans are in place to establish one at St Michael's. However, even if this does come to fruition, and there is, we submit some considerable doubt and uncertainty about that issue, this will not be available for a minimum of 2 years. Table 3.6 of the needs assessment, that is, provides a summary of the ownership management of the clubs within the catchment area. 3 of the clubs, Eccleston Park, Sutton Hall and St Michael's, are included in the figures, but they were not functioning. A summary of the data analysis is provided, and it states, and I quote, England Golf's current strategy has numerous aims, including the strengthening of the governance of courses and clubs, to support clubs with member recruitment and retention, and to advocate and inform on all elements of sustainability. To achieve this, there is an emphasis on being open to change where appropriate and encouraging different offers and formats of the game that will appeal to an increased market. Residents in Halton have lower than average propensity to take part in sport and physical activity, and whilst golf is reasonably popular, participation levels are still below regional and national averages. This may, however, be counterbalanced by the high proportion of 55 to 69-year-olds in Halton, whose numbers will continue to grow. And just let me pause there for 1 minute, sir, to make the observation that was relied upon in Miller & Friends closing and is repeated throughout Mr. Smith's evidence. This national statistic of a number of golf courses per representative part of the population, the 20 to 25,000 that's referred to in Miller & Friends closing, that is not the methodology that's encouraged by England Golf. A more bespoke analysis, a more robust analysis specific to the circumstances of the site is what is required and what was undertaken as part of the needs assessment in this case. So returning to my closing, quality of the golf club, my paragraph 9, the golf club undertakes its own maintenance. The course is considered to be a good standard in terms of the conditions of the greens, tees, fairways and bunkers. As was noted on your site visit, it can be soggy underfoot. There are a number of perceived and actual issues relating to the proximity of housing and the road surrounding it. This applies to a number of health and safety related issues. Holes on the outer part of the course closely border surrounding houses and a main road. However, the quality of the ancillary facilities also detracts from the quality of provision. The clubhouse is poor quality and the building is unsuitable in its current form. This includes the changing facilities, the greenkeepers area, the pro shop, all of which are in need of redevelopment. The accompanying car park is poor and in need of improvement. It is limited in size, providing fewer than 100 spaces that is insufficient for times of high demand, such as competition events. Blundell's Hill Golf Club is also perceived to be a good quality course. The needs assessment expresses the view that the provision at Blundell's Hill is unlikely to appeal to older members of the current club on account of them being more used to playing on a shorter and flatter course. Blundell's Hill is substantially longer, more undulating, and with several holes in a relatively steep incline. In qualitative terms, the need assessment expresses the view that joint management of both Blundell's Hill and the club could lead to all types of golfers and members being catered for across the two courses. It could lead to management efficiencies, allow players to play both courses without additional cost, supporting a golf development pathway. The quality of ancillary facilities at Blundell's Hill is of a higher standard, including the clubhouse, which differs markedly in terms of space, function areas, modernity of changing facilities and car parking provision. In terms of pricing, England Golf reports that the average cost of full adult membership nationally is £901. This slightly below the current fees at the golf club itself. Turn then to demand. The needs assessment notes that around 2004 participation in golf began declining. Prior to the pandemic, there was a levelling off of the decline, and following the lifting of the COVID-19 restrictions in 2020 and 2021, the demand for golf was noted to have increased. The needs assessment notes that a significant opportunity now exists to retain increased participation in the long term. Average membership in England per golf club is 484. Before 2018, demand for golf, and in particular membership of a club, had fallen over the previous decade. There was a corresponding rise in nomads. The analysis of the golf club is that the current average membership of a golf club consists of 381 adult men, 70 adult women, 27 junior boys and 6 junior girls. Club memberships supplied by the golf club shows that at the time of the needs assessment, it had 327 members, 157 below the national membership average. Table 3.9 showed the changes in demand since 2015. This demonstrates that the reduction in membership was not unique to the golf club. Indeed, the greatest percentage shortfall was in respect of, I hope I'm pronouncing this right, at Shardley Park and Runcorn golf clubs, where there was 47% decline experienced by both. Interestingly, across all the clubs in 2015, there was a reduction from 4,698 members to 4,107 members, comparing 2015 and 2018. This amounts to a reduction of over 14%. The evidence of the NA, and if I may say so, accepted by the local planning authority, demonstrates that virtually without exception, the majority of clubs within the catchment area have capacity to increase membership. Only Shardley Park was not accepting new members, albeit that this is set to change this month when new applications would be welcomed. Some emphasis has been placed by the local planning authority on England Golf's assessment of latent demand that identifies that 24% of adults in England are potential players, consisting of lapsed and latent players. However, this is effectively a marketing tool to be deployed by individual clubs to identify by golfing profile those likely to be attracted to their individual facility. The analysis in the needs assessment is that the demand for this golf club is lower than the average across the catchment area. It goes on to observe that it should be reduced, should it be reduced to a 9-hole course, it would continue to appeal to most of the segments as currently identified, as well as appealing to more of the independent segments, as the facility would be easier and quicker to play. An interesting feature of the accessibility issue, bearing in mind the local planning authority's case and the need for a Widnes 18-hole facility, is that over 20% of the existing golf club membership already comes from outside of the district. The needs assessment further shows that the likely travel patterns of golfers should the appeal proposal proceed, this evidence suggests that Blundell's Hill would be the major beneficiary should members leave the golf club. Supply and demand analysis. The needs assessment considered the issue in accordance with Sport England guidance, looking at quantity, quality, accessibility and availability. In quantitative terms, there are 12 standard 18-hole golf courses within 20 minutes drive time, excluding the current club. This is a comparatively high number, as well as 2 driving ranges offering some 46 bays. A number of facilities have closed and reopened during the last few years, indicating the volatility in the local market. There is an absence of par 3 or 9-hole courses in the catchment area, indicating a gap in the market for such provision. The proposal will lead to a reduction of 9 holes, but will create the only standalone 9-hole facility that will also be capable of providing a standard hole course. In qualitative terms, whilst the course itself at the golf club is in relatively good condition, safety issues persist with narrow fairways, close proximity to houses and roads, and play being crossed. The clubhouse is below standard. As such, it needs to be replaced or extensively refurbished. It is currently unfit for purpose. The car park is uneven and poorly maintained. The quality of other courses is generally good, including courses and ancillary facilities, and that includes Blundell's Hill. The facility at the subject club is markedly different to that provided at Blundell's Hill, as it is much shorter and flatter. Accessibility. This is towards the lower end of the scale. Full membership is above the national average. The large majority of the courses within the catchment are assessed as being above average difficulty. The proposal should lead to an increase in Blundell's Hill at more affordable rate, and more particularly enable a player pathway to be created given the differences between the 2 golf offerings. Availability. There is clearly current capacity in the catchment, with all but 1 club offering additional membership, and this club will be offering membership as of this month. Only 4 clubs are operating above the national membership average, whilst the remainder all have fewer members. At the golf club, membership is reducing. The majority of other clubs have also seen a reduction in membership. And can I just add, sir, that seems to me, in my submission, address the point that Mr. Hunter was making. Not only is there availability and members are being recruited, but if you actually look at the numbers of those members, the capacity is plainly there. In terms of then the proposal, the detail of the proposal is provided in the needs assessment and supporting documentation. The new course layout will feature 1 par 5, 5 par 4 and 2 par 3 holes that will maintain its status as a traditional standard hole course. The reconfiguration will enhance the quality of provision, but also make it safer to play and access. A new clubhouse and greenkeeper storage unit will be created, as well as a new vehicular access, car parking, green footpath link and ancillary development. The development would enable the takeover of Blundell's Hill to provide a flexible joint membership package with beginners golf, casual players, female and disabled golfers more likely to use the current club, then progressing to the longer and more challenging course at Blundell's Hill. With its current membership base, the club is not in a financial position to address the deficiencies identified above. As a consequence, it will become increasingly difficult to attract new members and secure financial sustainability. The only empirical evidence of golf club membership opinion is that undertaken in February 2020, when there was a survey of membership. Some 58% would use both the existing club and Blundell's Hill, with only 7% using neither course. Paragraph 99 of the framework. The appellants can demonstrate compliance with both subparagraphs A and B of paragraph 99. In terms of surplus, in context, the framework states existing open space, sports and recreational buildings and land, including playing fields, should not be built on unless A, an assessment has been undertaken which has clearly shown the open space, buildings or land to be surplus to the requirements. The essential difference between the parties is the starting point for the assessment. The starting point for the assessment must, it is submitted, be the loss that's involved. In this particular case, it is 9 holes, not 18 holes, that is considered to be the surplus to requirements. That conclusion is arrived at and derived from the findings of a number of factors set out in the needs assessment, and they can be summarised as 327 current members capable of supporting a 9-hole facility without any capacity issues. It's potentially unsustainable to continue to function as an 18-hole facility if the decline in membership continues. This is contrary to the national trend of increasing participation, although it will be noted that 2015 to 2018 participation in membership of clubs reduced by some 14%. There would continue to be sufficient capacity, including that of Blundell's Hill, to play an 18-hole facility. A 9, 12, 18-hole game can be played on the reconfigured course at the club. There are 16 other golf facilities, 13 of which are 18-hole courses within the 20-minute drive time catchment. All have capacity and are accepting and actively recruiting new members. This is clear evidence that capacity exists. If, as is the local, as in accordance with the local planning authority's case, the St Michael's golf course, which is about 1.5 miles away, proceeds, this will add further capacity in the catchment. There is currently no 9-hole provision within the catchment. This is a gap in the golfing market, which will be exploited by the club as being more attractive to beginners, those time-pressed and casual golfers, younger and older players. Importantly, Mr Smith, in cross-examen, acknowledged the needs of golfers within the catchment area would continue to be met in the event that the appeal proposal went ahead. The local planning authority's case is that a town the size of Widnes would be expected to have an 18-hole golf course, and use of population ratios suggests that the retention of an 18-hole facility is justified. This approach is misguided. Firstly, there is no requirement for any town or administrative area to have a certain number of 18-hole golf facilities relative to a given population. There would remain within the catchment a number of facilities that could be appropriately accessed to meet such existing golf needs as been demonstrated in the needs assessment. Secondly, the use of ratios is an inappropriate and unsubtle tool in order to make a judgment on provision. It no longer forms part of Sport England's intended approach to needs assessment. The rationale for doing so is to recognise that every area is different and that a needs assessment has to be based upon a specific, locally tailored supply and demand analysis. Mr Wright, in his written rebuttal evidence, pointed out that Sport England specifically asked that an analysis of ratio standards was not to be run for the appeal proposal, and this evidence he was not challenged upon. Beyond this, it is noted that the council's own 18-hole golf course in Widnes that closed in 2004, this has not been brought back as an 18-hole course, and at least now it is used to accommodate solar panels. The site visit confirmed that the opening of the course for 9 holes and a driving range will not be imminent, and third parties participating in the inquiry questioned whether the course would ever be brought back into use by the council. A full planning history of St Michael's in relation to its use for golf is set out in document AD 052. The local planning authority accepts that the necessary permissions are not in place for the driving range and earth is still being deposited for the course. It follows that seeding, at least seeding in construction of the clubhouse, remains outstanding, and on any realistic view, this necessarily means the earliest one could expect it to be available for use would be counted in years and not months. Turning then to the second issue, equivalent or better provision. The context of the relevant passage from the framework states existing open space, sports and recreational buildings and land, including playing fields, should not be built on unless the loss resulting from the proposed development would be replaced by equivalent or better provision in terms of quantity and quality in a suitable location. There is something of an ambiguity in the interpretation of this policy. At its simplest, the ambiguity arises because the consideration of what amounts to the loss to the open space and recreational buildings and land will be replaced by equivalent or better provision in terms or of quantity or quality, or that the quantum of land lost is largely immaterial because the replacement is that of the provision in terms of quantity and quality. As the cross-examination established, replacement provision in a suitable location that met square metre for square metre, the loss would meet the policy test. However, whilst there may be a loss in the quantum of land the policy is complied with, where the replacement provision, albeit on a smaller area than which it replaces, amounts to an equivalent or greater provision of the recreational loss. The example of the loss of conventional playing pitches being replaced with an all-weather pitch that facilitates greater use than the conventional ones is an illustration of the point. Elucidation of these terms can be found in the analysis of Inspector Baird in the Bicester case. Whilst it was an earlier iteration of the framework, the relevant wording is identical and is therefore of direct application. The description of the development included the redevelopment of part of a golf course to provide a new leisure resort. The appeal was allowed. It is clear that the development involved the loss of the back 9 holes, the driving range upgraded, and the outfield would be shared with a 9-hole academy course. It is indisputable that all of the land that was lost in this context was land actively used in relation to recreational golf. The inspector makes it clear at paragraph 47 that B is in the context of the test being the provision in terms of whether it is equivalent or better, relates to what is being lost. Specifically, paragraphs 56 to 60, that's of the Bicester decision, sir, deal with the framework paragraph 97, as was. It is also worthy of note that the inspector identifies that the reconfiguration of a 9-hole facility can contribute to increased participation in the sport and, as in this appeal proposal, those who would wish to play an 18-hole round could continue to play 9 holes twice. His paragraph 60 states, and I quote, "Along with the benefits of the upgraded driving range and the introduction of the academy course, the reconfiguration of the front 9 holes would on balance provide at least equivalent provision in terms of quality and quantity. In quantitative terms, whilst there would be a loss of 9 holes, the reconfiguration in the appeal proposal does not involve the loss of quantity of the recreational facility, which would continue to be able to be played twice, as in the Bicester case. Alternatively, if one were to consider provision and adopt the approach of considering what is lost, then the same logic can be applied to the appeal proposals. In particular, provision would be improved in both quantitative and qualitative terms because of the improvements to the reconfigured golf course and associated facilities, together with Blundell's Hill and improvements to its facilities. There would be no loss at the golf course, the subject golf course, of an 18-hole facility for exactly the same reasons as Bicester. There would be a clear qualitative improvement to the facilities, not just limited to health and safety considerations, but also in terms of attractiveness to potential golfing communities and markets. There are additional benefits associated with investment at Blundell's Hill, secured by the 106 unilateral undertaking. The Sport England position. The latest Sport England position objects to the proposal. It is unclear whether their position was informed by a site visit. Certainly no site visit was referenced. The case on 99A wholly misrepresents the appellant's case and the content of the needs assessment. The case has never been put or evidence provided on the basis that surplus to requirements in national policy was that of the operator. It would and should have been quite apparent on any fair reading of the needs assessment that the surplus to requirement was that of golf, and the needs assessment was prepared and provided in accordance with recognised experts and by recognised experts that applied the Sport England methodology. It will be noted that at no point does Sport England provide any alternative evidence to the inquiry that undermines the content of the needs assessment analysis. The Sport England case on subparagraph B asserts that no replacement to an equivalent or greater quantity golf course land, an equivalent or better in a suitable location has been put forward. Only qualitative improvements to the retained part of the golf course and Blundell's Hill golf course have been put forward. This response betrays a misunderstanding of national policy. This is the quantum of land point that I discussed above. The word provision is not referenced in the Sport England objection. A reduction in the area of land available is compliant with policy where the provision is equivalent or better, as is the case in the appeal. The needs assessment reference framework 99B case and the appropriate considerations. And I would add this, that if the Sport England interpretation was correct, it necessarily means that BISTA was wrongly and unlawfully decided. Planning obligation. Ms Tighe has addressed this. The appellants have provided a SIL compliance statement. The UU contains appropriate mechanisms to secure delivery and improvement to the club, the acquisition of Blundell's Hill and improvements there. The benefit is to golf and not to individuals. The Council considers that the UU does not meet tests A and C for a planning obligation as set out in Regulation 122 of the Community Infrastructure Levy Regulations, and in doing so rely upon the evidence submitted. This we deal with in the SIL compliance statement. Importantly, the concerns of the LPA do not address the status of the club in its responsibilities as a community amateur sport club, a CASC. It allows local amateur sports clubs to register with HMRC and benefit from a range of tax release where a club meets the qualifying conditions. The government's detailed guidance notes require a CASC to be organised on an amateur basis, be non-profit making, be non-discriminatory, and to have fees that do not represent a significant obstacle to membership or use of the facilities. CASC membership is intended to be permanent. There are clear tax consequences for a club to seek to that would seek to renege on the benefits it has enjoyed as a CASC, as the guidance notes make it clear. Quote, it's important for club members to fully understand what CASC status means before applying. For example, if there is any chance that they may want to sell off the ground for development in the future and share the profits between them, then CASC status is not a suitable option. In the event of dissolution of the club, the members must apply its net assets for CASC-approved sporting or charitable purposes. Her Majesty's Revenue and Customs deal with the issues involved, but for the purposes of this inquiry, the precise details of what the proceeds of sale will fund, as the CASC can only exist for the purpose of supporting the sport. On this basis, it will be Revenue and Customs that provide the assuredness that all of the net proceeds of the sale of the site for housing will be ploughed back into the provision of and support for golf facilities. Turn to the second issue, the effect of the proposed development on designated green space. In view of Malone & Friends' paragraph 20 of his closing, acknowledging that the Council is not pursuing this matter further, I can deal with this very briefly, sir. I think if one goes to my paragraph 50, I think I summarised the position, and this is where I believe the Council's concession is derived from. If I just read this out for the members of the public, policy CSR 21 deals with green infrastructure. This is not the same as green space. Policy HE4 dealing with green infrastructure and green space. It is clear that the policy designations HE4 and 6 are and were intended to be mutually exclusive. The relevant policy to be applied in respect of the appeal site is HE6. It is no longer covered by a green space policy. Green space policy is found exclusively in HE4, which excludes golf courses. Consequently, policy HE4 is not applicable or even relevant to the appeal proposals. It follows that the appeal proposals should only be considered under policy H6 in relation to outdoor sports provision. I turn to the third issue, the effect of the proposal on highway safety. In respect of this topic, the issues that were between the main parties to the appeal have narrowed significantly. The Highway Statement of Common Ground identifies that the vehicular access arrangements to the development are shown on the plan which I've identified. The arrangements include 2 new connections on Liverpool Road and involving priority control junctions, construction of a 5.5 metre wide site access, provision of a 3 metre wide footway on both sides of the access narrowing to 2 metres, a Ghost Island right turning lane provision and a 10 metre curbed radii. The local planning authority accept the principle of priority control Ghost Island junctions for both access points. At its simplest, the LPA objection relates to the proposed access positions and the prospect of conflict with the use of existing private access serving development to the south of Liverpool Road. In relation to the western access, serving the development, the concern here relates to numbers 57 to 65 Liverpool Road. The eastern access relates to the former St Raphael's Church, which is now currently being managed as a housing in multiple occupation. This is covered in considerable detail in the evidence of Mr Woolliscroft and the rebuttal. In terms of the western access serving 57 to 65, it's claimed in the evidence of Mr Woolliscroft the western vehicular access to the appeal site is staggered and that additional road markings to denote 2 distinct right turning pockets into the appeal site and the private residential drive could be provided. Appendix 9 to his evidence includes a swept path analysis of a refuse vehicle turning right from Liverpool Road to the appeal site and a large rigid HGV turning right into the private drive to the properties lying to the south of Liverpool Road. The 2 swept path analyses do not conflict with each other and there is a comfortable gap between the 2. This would be a profoundly rare occurrence in any event. The traffic survey data carried out over a 12-hour period on 2 separate days shows that there are only 7 right-turning movements throughout the 12-hour survey. That equates to around 1 right-turning movement every 2 hours during a typical day. The survey didn't identify any HGVs. Indeed, when pressed by the inspector, Mr Peake accepted that the western access design could be similar to that proposed by Mr Woolliscroft and could be dealt with by an appropriately worded condition. The remaining concern was expressed for the first time in the evidence of Mr Peake. The rebuttal of Mr Woolliscroft in relation to the concern addresses the existing access to St Raphael's Church. And I'm quoting from it, "This is not an issue that has been raised at all during the planning application process whatsoever, despite the access of the church being shown on both the Edison's access plans and the annual site layout plans. The issue was not raised at all within the consultation response for the appeal application, or indeed the previous appeal planning application, which is exactly the same eastern site access arrangements. The statement of common ground only identified the area of disagreement being with the western access points proximity to those properties at 57 to 65 Liverpool Road. Now, notwithstanding the late introduction of a new issue, the appellants commissioned a traffic survey to inform the response to the late case presented by the LPA. This demonstrated that the church access was very rarely used. There were in fact only 4 right-turning vehicles during the 12-hour survey. This clearly demonstrated that right-turning vehicle into the church access was extremely rare, and the prospect of conflict with any movement to the appeal site access even rarer. Mr Woolliscroft observes that there is nevertheless an opportunity to slightly relocate the eastern access to the east to create a small stagger between it and the church access, and this could be within the tolerances typical of a Section 278 Highways Act design process. This is shown on drawing number 2224 F08 attached to his rebuttal evidence. Nevertheless, as is made clear in the rebuttal, the currently proposed vehicular access is, to use his words, entirely appropriate. Third parties raised a number of additional points about pedestrian safety in the area, particularly in relation to school children travelling in the vicinity of the appeal site. It is clear from the evidence that there are numerous improvements relating to this issue being offered by the appellants. These include the introduction of a 3-metre wide footway along Liverpool Road frontage, a new pedestrian refuge at the western access on Liverpool Road, and the opportunity to walk between Highfield Road and Liverpool Road across the site rather than walking along the roadside for all pedestrians. These provide a substantial improvement to the safety and efficiency of the local footway network. Flood risk and drainage is the fourth issue. The planning application was supported by a flood risk assessment that included a detailed site-specific hydraulic modelling exercise. There is no challenge to the technical assessment of the proposal. The issue concerning flooding and drainage have been substantially addressed in the course of the evidence, and it will be noted that save for a small area located north of Liverpool Road, near Moss Brook, the site is located outside the 1 in 1,000 annual probability fluvial flood event, i.e. it falls within Zone 1. The hydraulic modelling undertaken to assess combined fluvial and surface water flood risk identified 2 points. The potential for shallow flooding, that is less than 0.1 metre, adjacent to the eastern boundary following the 1 in 100 annual probability event, and secondly, the potential for flood water to pond directly north of Liverpool Road to a maximum depth of 1 metre during the 1 in 1,000 annual event due to the capacity of the Liverpool Road culvert, which would result in inundation to the rear gardens at Woodland Avenue. As a consequence of changes to EA advice, the hydraulic model was rerun to account for a plus 44% climate change allowance. The flood mitigation strategy, the FRA presents measures to ensure the development would be firstly safe in respect of flood risk and not increase risk elsewhere. The assessment reflected the most up-to-date EA guidance at the time on climate change. The evidence has addressed the latest advice and recommendations by the EA. It has demonstrated that the residential development platform, and indeed the golf club building, remains dry through all modelled events. With the flood risk mitigation measures in place, the flood risk would be mitigated from all sources of flooding and ensures that the development will be safe from flood risk for its lifetime. The mitigation consists of a range of proposals, including residential platform levels set well above the peak flood levels, the finished floor levels of the residential properties set at a minimum above the level of risk, channel improvements and the provision of compensatory flood storage, cut-off drain along the northern edge of the residential properties to direct overland flows towards upgraded ponds, and channel maintenance to minimise risk of channel or culvert blockages. The evidence further demonstrates that the proposed development would have a negligible impact on flood risk elsewhere. Indeed, the risk of flooding of rear gardens at Woodland Avenue would be reduced. In relation to surface water drainage, the proposals are based upon sustainable urban drainage systems, with the proposal to discharge surface water into Moss Brook. The greenfield runoff rates have been calculated, and the proposal will result in a reduction in more testing times of discharge. This will be achieved by providing 3 attenuation basins with oversized pipe network. The Statement of Common Ground succinctly sets out matters of agreement and those remaining in dispute. The following matters are agreed. The sequential test and exception test reported at Mr. Aldridge's Appendix 11 demonstrates that the proposed development cannot be located at an alternative site at a lower risk of flooding owing to the nature of the proposed development. The proposed flood mitigation scheme would prevent an increase in off-site flood risk in the present day 1 in 100 annual exceedance probability event, and would reduce the risk of flooding to rear gardens of the properties at Woodland Avenue. That the flood mitigation strategy works would adequately mitigate the risk of combined fluvial and surface water flooding. In the event of the failure of the bund forming the easternmost flood storage area, the existing dwellings on Woodland Avenue would not be at a residual risk of flooding. Limiting the proposed surface water discharge rates to greenfield runoff rates is appropriate, and the proposed drainage system and attenuation storage facilities would cater for the 1 in 100 plus 40% climate change probability storm event. The 2 areas of dispute are, firstly, it's not agreed that the residential development is appropriate within the floodplain of Moss Brook, and secondly, it's not agreed that the proposed development provides wider sustainability benefits that outweigh flood risk. In relation to 2, this is a matter dealt with in the evidence of others and will be addressed in the course of these submissions in the context of national policy framework. Paragraph 159 provides inappropriate development in areas at risk of flooding should be avoided by directing development away from areas of highest risk, whether existing or future. Where development is necessary in such areas, the development should be made safe for its lifetime without increasing flood risk elsewhere. The guidance presents Table 3, flood risk, that should be vulnerability and flood zone compatibility, and indicates that water compatible and less vulnerable development is appropriate in flood zone 3A, and that more vulnerable development is also appropriate, subject to the application of the exception test. Table 3 in PPG is reproduced at Figure 1 in Appendix 11 to Mr. Aldridge's evidence. Paragraph 162 of the framework deals with a sequential test which is to steer new development to areas with the lowest risk of flooding, and it continues, development should not be allowed or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. In terms of the sequential test, as the proposals include a reconfiguration of the existing golf course and consequently, and if I may say so, self-evidently cannot be located elsewhere, as is the residential development that facilitates those changes. Barton Wilmore provided Appendix 11 to the evidence of Mr. Aldridge. It confirms that it is inappropriate to locate the proposed residential development at the north of the site, where it is acknowledged flood risk is lower, because the only reasonable vehicular access is at the south via Liverpool Road. The wider sustainability benefits required to outweigh flood risk are also set out in their evidence and closely follow the framework and its approach to the 3 strands of sustainability: economic, social and environmental. Remaining issues. Firstly, Mr. Dennison requires infiltration analysis, the necessity for which is challenged. Even if wrong on this, all the matters can be addressed by an appropriate worded condition, and it will be noted that condition 29 of the then draft condition deals with these issues. The approach of Mr. Aldridge, should it is submitted, be preferred, it follows from the BETS Geoground Investigation Report. The report at Chapter 9 discusses the intrusive borehole analysis that was conducted, and I quote from the observation in that report: soakaway tests were not undertaken as part of the BETS geofield work, given the majority of the site is covered by cohesive superficial deposits, and use of infiltration is not likely to be a suitable surface groundwater drainage option. This is a properly informed expert view to which weight can be ascribed. Mr. Aldridge's conclusion in light of that evidence is robust. Secondly, there is an ongoing concern articulated in respect of maintenance of flood defence infrastructure. The infrastructure comprises an earthen bund of a maximum height of 400 millimetres. The maintenance model proposed in this case is not different from the vast majority deployed in other development sites. Thirdly, there is not a significant risk of erosion. This appears to be something of a misinterpretation of the landscaping plans provided, which illustrated the channel with vertical sides and a flat bottom. The more sophisticated and analytical drawings are those provided by Mr. Aldridge in his evidence. Fourthly, Mr. Dennison in his evidence introduces a point, accepted as being a completely new point introduced for the first time, that if the small part of the floodplain that is proposed to be developed for housing, it would not be available for future flood risk management schemes. There is no approved or even the prospect of works being proposed on privately owned land in the vicinity of Moss Brook. The approach of the local planning authority contradicts the framework. If a proposal meets the sequential test and exceptions test, as in this case, no justification for what would then be a policy compliant proposal to establish that the land will not, at least for the foreseeable future, be required for flood mitigation or flood risk works. I then draw together the trees and landscaping point. It's perhaps an unusual feature of this case that landscape arboricultural issues have been elevated to a significant part of the local planning authority's case. in circumstances where it is not considered even appropriate for the local planning authority to request an LVIA. The landscape evidence prepared for the inquiry by both parties has adopted the broad methodology in Glivia 3. The professional judgments expressed are precisely that. They are different, but seek to inform the decision maker's judgment. The appellant's case is to start by recognising that the appeal site's urban setting, with adjacent dwellings, the presence of the busy Liverpool Road, the railway line, schools and sports facilities, all within the immediate context, adversely affecting tranquility. The appeal site is within the settlement boundary and is obviously within an urban setting. The description of openness is contradicted with the sense of enclosure provided by the existing vegetation as demonstrated in the photographs. The residential development proposed is appropriate and not uncharacteristic of the existing appeal site setting. The appendix to Mr. Mitchell's evidence is correct when the witness observes that there is a foreshortening of the views from outside of the appeal site and within the wider character area. The discussion of the Barlow-Ditton Parkland landscape character area referenced the recently approved and built development to the south of Liverpool Road and the introduction of solar panels on part of the former St Michael's Golf Course. The development is located within the same LCA on former public open space and was determined to be acceptable. There's no public access to the appeal site and it has no role in providing wider recreational and well-being benefits. The development proposal nevertheless involves retention of existing trees with the highest amenity value. At the southern boundary, the retention of the existing skyline and verdant character of Liverpool Road will be retained. The new junctions to serve the development are located to minimise effects on views from King George's Park and results in minimal tree losses. Proposed public open space with play space located within the centre of the development to the north of King George's Park that provides an accessible corridor of public open space that connects with the new clubhouse and the public rights of way to the north. The local planning authority assessment by Ms. Quayle has stated it is demonstrated by the viewpoint locations. In the local planning authority's evidence, viewpoints 5, 6 and 7 were not being high magnitude of change even by her own, that's Ms. Quayle's analysis, and our evidence, the appellant's evidence, that this is even lower. Importantly, the viewpoint locations are, it will be noted, at the edge of the appeal site for the very simple reason that impact beyond that edge is profoundly limited. Turning then to arboricultural issues, the local planning authority's proof of evidence, which was attached to the evidence of Ms. Quayle, has some trenchant criticisms of the arboricultural assessment and the accuracy of the survey data. This essentially relates to estimations of height and circumference of some of the trees within the survey. However, the criticisms really do not take the case any further. The arboricultural impact assessment, irrespective of the TPO status of any trees or groups of trees, assess their value in accordance with the British standard. The statement of common ground recognises that all trees are material considerations in the planning balance, irrespective of their inclusion or otherwise in a TPO. The statement of common ground acknowledges that the tree survey and AIA is accurate in respect of tree locations. That's the arboricultural impact assessment, tree locations, species and root protection areas, while some differences in relation to height measurements are noted. It is acknowledged that the AIA is an appropriate document to assess the effect on trees. Furthermore, whilst the local planning authority's evidence contends that some other trees and groups may be detrimentally affected as a result of the works in the vicinity or future pressures for removal, it is considered that the potential detrimental effects on the trees have been considered in the AIA and effective mitigation measures would allow tree retention. The scope of special construction methods in the arboricultural method statement show the appropriate and, if I may say so, well understood means of protecting retained trees or trees intended to be retained. The development of the site would necessitate tree removal, but would also provide new tree planting. The landscape master plan makes provision for 328 medium to large trees and 207 small trees capable of being secured as part of the appeal process. Excuse me. Tree canopy cover is approximately 25%. Both parties agree that following tree removal and replacements, the tree canopy cover after 20 years will be around 22%. The additional information provided shows that 18.5% tree canopy cover would remain from the outset of occupation. The former UDP policy G28 relating to the Mersey Forest initiative was not carried forward into the new local plan. Consequently, there is no remaining policy consideration in relation to that initiative. The issues of species diversity is not a material matter. There are 37 different species currently present on the site. Taking account of tree removal and replanting plans before the appeal, there would be 35 species present following development. The parties agree that the current landscaping planting scheme contains a mix of species that are appropriate for the site. Then turn to development plan policy. It is essential in understanding the structure of the policies to have an appreciation of the process by which the relevant policies were arrived at in their final form. The appellant was responsible for a challenge to the soundness of the approach to green infrastructure, green space and open space and sport provision. Essentially, the policies didn't distinguish between the same, and it was unclear what policies were relevant to certain areas of land. At the examination in public, that was acknowledged by the inspector. The local planning authority was therefore tasked with redrawing the policies in accordance with the criticisms made. The inspector's final report deals with open space and green infrastructure at paragraphs 2, 3, 4 and following. So I'm proposing to take the next 3 paragraphs as read because they essentially deal with the issue which was the second matter in the main issues. In fact, I think I can take paragraph 95 as read as well. I'll begin at 97. The previous paragraphs deals with the inconsistency between the two policies. Paragraph 97, a similar sentiment was expressed in respect of policy HE6 being ambiguous and including duplication of policy HE4. The inspector's analysis included MM44, main modification 44, where the inspector had said an effective approach to recreation and sports facilities, including indoor and outdoor sport provision, taking into account the particular demands and identified needs for sports and playing pitch facilities in the latest Halton Playing Pitch Strategy 2020. Importantly, in this context, the Playing Pitch Strategy 2020, ironically prepared by KKP and Mr. Wright under instruction from the local planning authority, did not assess the need for golf provision within the borough. As a consequence, there is no evidential basis to support the application of policy HE6 in terms of any assessment of demands, and I've emphasised the word identified because that's the word that appears in the policy, identified needs for golf facilities. Put simply, no need for golf facilities was even assessed, let alone identified. It's noted that Part 6 of HE4 specifically states that the requirements for formal indoor and outdoor provision are contained within policy HE6. A further main modification identified required the removal of the reference to outdoor sports facilities and formal playing field standards in the table associated with CSR 21 in order to be effective and consistency with national policy. The main modifications and changes proposed to the then emerging local plan were identified in document PDA L015, and I summarise them as follows. Main modification 17, deletion of the reference to outdoor sports facilities in CSR 21. 42 deals with HE4 and its amendments, including those that I've set out below, so I don't need to read them because they are no longer relevant. Policy HE6, the title, this is C, the title of the policy changes to outdoor and indoor sports provision. The policy is amended closely follows the framework paragraph 99. Subparagraph 2C of the local plan now states the council will not permit development likely to result in an unacceptable loss of existing sport or recreational facilities for non-recreational purposes unless it can be demonstrated that the site facility is surplus to recreational requirements and is not capable of helping to meet any of Halton's identified needs. As stated previously, the evidence base accepted by the inspectors dealing with the plan found that green space and green infrastructure was in surplus across the borough. And so the footnote gives the reference to the paragraph that is the specific finding. And secondly, that the identified needs were by reference to the playing pitch strategy, that had found that there was not a need for additional land to provide pitches, but an approach involving enhancement and improvement of the existing infrastructure. And so that flits back to subparagraph C that has a policy requirement to really address the question of whether the site would be capable of helping to meet any of Halton's identified needs. Well, it didn't identify any needs. My paragraph 101, as addressed earlier, HE4 and 6 are mutually exclusive. The policies relating to green space don't apply. HE6 is therefore the main policy, and the inspector's report stated in respect of main modification 44, it's required to set out an effective approach to recreation and sports facilities, including indoor and outdoor sports provision, taking into account the particular demands and, underline these words, identified needs for sports and playing pitch facilities in the latest strategy. The amended wording to policy HE6 and its supporting text deals specifically with this issue in line with advice from Sports England, and we recommend this for effectiveness and consistency with national policy. A range of sports and activities are referenced at 1263 and 65 of the local plan without any mention of golf, and 1264 suggests the requirement for outdoor sports facilities is likely to be fairly constant in the plan period. Excuse me. Thus, my 104, there is no evidential basis for considering golf under HE6. The ALPA has not considered golf in any previous evidence-based document. The only evidence is Mr. Wright's needs assessment, and in this context the framework paragraph 98 is relevant. Access to a network of high quality open spaces and opportunities for sport and physical activity is important for health and well-being of communities and can deliver wider benefits for nature and sport efforts to address climate change. That planning policy should be based on robust and up-to-date assessments of the need for open space, sports and recreational facilities, including quantitative or qualitative deficits or surpluses, and opportunities for new provision. Information gained from the assessment should be used to determine what open space, sport and recreational provision is needed, which plans should then seek to accommodate. The framework paragraph 98 casts considerable doubt on the extent to which HE6(2)C can be applied in this case simply because there is not any assessment of golf needs, let alone one that could be characterised as based on robust and up-to-date assessment of such need, to measure any assessment of loss upon. Almost counterintuitively, a point made by Mr. Hunter in his closing, discussing whether policies resolved to be adopted only days before by the local planning authority to be considered out of date seems somewhat bizarre. But policies that are by their nature formulated on an evidence base, in circumstances where the evidence base is wholly absent or out of date, engages consideration of the application of the tilted balance at 11D of the framework. In this case, there is no evidence of golf needs in Halton. It was not assessed. The absence of an assessment is an approach that is inconsistent with the framework paragraph 98, as I've set out above. The policy is therefore, at least in respect of golf need and provision, unsupported by any up-to-date evidence base. HE6 as a policy being the most important for the determination of the appeal following the adoption of the local plan is not therefore up to date, as it is inconsistent with the clear exhortation in the framework that such policy to be supported by robust and up-to-date evidence. As such, there is a clear case, as expressed by Mr. Mitchell, for consideration of the application of the tilted balance. Save for one point, the policies of HE6 do not differ from the framework. The relevant part of the policy is the protection and enhancement section. In terms of 2A, this is not relevant, as the proposals are not wholly ancillary to the sporting use of the land. 2B is expected to be reworded consistent with the main modification, that replacement sport and recreational provision of at least the same or better quantity and quality and in a suitable location to meet the needs of the existing sport and recreational facilities. The evidence produced as part of the application appeal shows that the proposed reconfiguration of the golf club would result in at least the same quality and quantity of provision as currently present. See the discussion of compliant with paragraph 99 of the framework for more detail set out above. Insofar as HE62C is engaged, and where the site facility has been found to be surplus to requirements, this further requires some consideration of whether the site facility is capable of helping to meet any of Halton's identified needs. The land has been shown to be surplus to recreational requirements, and the Council's playing pitch strategy and open space studies have shown that the deficiencies present in the borough do not require additional provision of land to rectify them. As such, the land is not required to meet identified needs. Indeed, no part of the local planning authority's evidence has suggested that further recreational land is required and that the appeal site would be well suited to addressing any such shortfall. In terms of HE63, the relevant part of wording implies that this relates to new facilities. However, the proposed development has been designed to increase accessibility for the general public to the land through the provision of public open space and a green footpath link. In the event that the flat balance is considered to be appropriate, the appellant's case is that the framework 11C applies, policy CSR21 and HE6 and the flood risk policies apply national policy. The coincidence of evidence addressing the framework policy and development policy leads to the conclusion that the proposal is policy compliant. I turn finally to the planning balance. Conspicuous by its absence in any of the written evidence submitted to the inquiry on behalf of the local authority is an acknowledgement that there would be benefits associated with the proposed development. And Mr. Eaton, on behalf of the local planning authority in his written evidence, does not acknowledge the sustainability benefits in accordance with the framework, which are an essential feature of the determination of planning applications appeals in a post-framework world. As previously set out, the appeal proposal conforms with the provisions of the local plan March 2022. If it is compliant with the framework paragraph 99, it must also accord with the statutory development plan. I've previously addressed the issue in respect of paragraph 2C of policy HE6. There is no identified need for a golf course. The examination during the course of this inquiry of golf needs is addressed earlier, but that is not, it should be pointed out, an identified need in policy terms. The assessment of Mr. Wright is a bespoke assessment and analysis of this appeal. There is no dedicated assessment of wider golf need to inform the local plan or wider decision making provided by the local planning authority. In respect of the appeal proposals, a number of third-party objections have been raised. It's essential to recognise that there is no local planning authority objection on ecological grounds, heritage or archaeological grounds, congestion, traffic volume grounds, air quality grounds or noise. The evidence of Mr. Mitchell establishes that the proposed scheme would create a high quality environment for future residents, that it would deliver an appropriate quantum of open space, that it would make a policy compliant contribution to meeting affordable housing needs, some 60 units, that as the appeal site is recognised to be locationally sustainable, allowing future residents real choice of non-car modes to access services and facilities, that as the appeal site is proximate to Widnes, Halton's highest order settlement, that whilst the local planning authority is acknowledged to be able to demonstrate a 5-year housing supply, that is not a reason to refuse the grant of planning permission for new market and or affordable housing, that there is no objection to the redevelopment of the clubhouse, and that there's no objection in principle to the reconfiguration of the golf course. But policies that are by their nature formulated on an evidence base in circumstances where the evidence base is wholly absent or out of date does engage consideration of the application of the tilted balance. In this case, there is no evidence of golf needs in Holton. It was not assessed as part of the local plan. The absence of assessment is an approach that is inconsistent with the framework. Turning to the benefits, the provision of market and affordable housing, even where a 5-year supply can be demonstrated, is a benefit of the proposal that attracts weight. Paragraph 60 of the framework, as indeed all previous iterations have done, expresses the government's objective to significantly boost the supply of homes. More particularly, the current government objective is to deliver 300,000 homes in England per year, adding at least 1 million homes by the end of the current Parliament in 2024. As Mr. Mitchell points out, emerging evidence suggests that the 300,000 target is too low, and one of 340,000 per annum might be more appropriate. Mr. Eaton, in his evidence regarding the provision of market housing as neutral in the planning balance and that of affordable housing of little benefit. This, if I may say so, is an incredible position to adopt and seriously undermines the planning balance assessment by the local planning authority. On any view, the officer charged with balancing the issues has gone seriously awry. Hence, in re-examination, Mr. Hunter was scrambling back with Mr. Eaton on a hypothetical basis that if greater weight was to be given to these important issues, the result would be the same. This is simply retrofitting a case and did not bear in the analysis of the planning balance that was actually conducted by the local planning authority. In terms of the appropriate weight to be given to the contribution of market and affordable housing, we make reference to the Secretary of State's own decision in the Nantwich appeal. In that case, the Secretary of State found a supply ranging between 5.7 and 6.6 years, and then the Secretary of State to conclude. The Secretary of State agrees with the Inspector that the delivery of significant numbers of market housing in a sustainable location is a significant benefit. Whilst the Secretary of State has concluded that the council can demonstrate a 5-year supply, he has taken into account that nationally it is a government policy imperative to boost the supply of housing, as set out in then paragraph 59 of the framework, and he considers that this benefit should be afforded significant weight. The Secretary of State also agrees with the Inspector that the scheme will include 30% affordable homes, which will help meet the needs in Cheshire East. Secretary of State agrees that this is a tangible benefit and merits significant weight. In respect of affordable housing, the situation in Halton, is particularly acute. The annual monitoring report 2021 is summarised in Mr. Mitchell's evidence. Between 2010 and 11 and 2019 and 20, save for the delivery through RSLs, no affordable housing was delivered. In 2019 and 20, of the 520 completions, not one affordable home was actually delivered. In this regard, Mr. Eaton's Appendix 9 shows that the 199 annual housing requirement, as set out in the Mid-Mersey SHMA, was that was part of the evidence base for the local plan, is nowhere near being met. Excuse me. The weight to be given to a contribution to meeting affordable housing need goes well beyond the arid analysis of numbers. As Inspector Harold Stevens in his report to the Secretary of State in the Pullet Lane decision observed, over the whole of the district's area, and there is presently a need for 268 homes per annum. These are real people in real need now. Whilst the situation is considered in that appeal attracted some well-deserved trenchant criticism, it will be of little comfort to those in need in Holton to consider that Wychavon residents might be having a worse time of it. Consistent with the objectives in the framework, paragraph 92, the on-site provision of affordable housing assists in the promotion of inclusive places that promote social interaction. Other benefits, in addition to market and affordable housing, the development itself would deliver a number of benefits, meeting the needs of the future residents and the wider community. These include the neighbourhood equipped area of play, the multiple use games area. These are to be centrally located and accessible to future residents and the existing community. The 2006 open space study noted a deficit of children's play provision. As such, in contributing to meeting a recognised existing need that is currently not being met, this is a benefit that carries weight. Open space and pedestrian links. The public open space will be accessible and available to future residents and the existing community. It will enable public access as of right. The pedestrian link between Liverpool Road through the development to Highfield Road is a benefit that attracts weight. It's a long-standing aspiration of local policy to achieve such a link, as appears from the proposals map of the UDP. The proposal will have a number of employment benefits during the construction phase and associated with the expenditure of future residents to support local services and facilities. Overall, the development represents a well thought out and sustainably driven proposal that appropriately and proportionately addresses the land use consequences of the proposal and delivers real and tangible benefits. The appellant acknowledges some harm in terms of localised landscape impact and loss of trees, but the benefits outweigh the harm on a flat balance. If the tilted balance is applied owing to HE6 being out of date, then further weight is added in favour of allowing the appeal. We therefore invite you, sir, to allow the appeal and grant planning permission for the development proposed. Thank you very much, sir.
Thank you very much, Mr. Barrett. Mr. Hunter, I noticed at one point there, I think we lost you for a moment. Were you
Yes.
disconnect, and is that likely to be a problem? I'm assuming that as we've got written submissions, you weren't out for very long.
No, I don't think so. It was about a minute or so. So yeah, I'm sure it's fine because Mr. Barrett was reading from his text. So
I was following closely. I think you dropped out. I was going to interrupt Mr. Barrett, but then I assumed that as you didn't say anything, you were happy to proceed. And not that I noticed, Mr. Barrett didn't move away from the text while you were. Thank you very much, gentlemen. I think that covers closings. Can I check? Are there any applications for costs?
No, sir.
Thank you very much. Now, I've received, while we were hearing closings, I've received updated documents in terms of the conditions. I understand these are now agreed. Obviously, I haven't had a chance to look at them. I don't think we need to necessarily go into any further detail at this point. But if I do have any queries on them, particularly on the pre-commencement conditions, I'm going to suggest that the best way to proceed would be then for me to write out, in the event that I was minded to allow the appeal and impose those conditions, if I have any concerns outstanding on the wording of them. Does anyone have any comments on that course of action?
No, we'd be happy with that, sir.
Okay, thank you very much. In that case, is there anything else that I should be expecting before we close? I don't have anything listed, just in case I've forgotten any other documents. No, I'm not expecting anything to come in now after the close of the inquiry either. Okay, well, in that case, are there any other matters anyone would like to raise?
No, thank you, sir.
oh, thank you.
No, okay. In that case, well, I think all that remains is me to thank everyone who's participated in the inquiry, the advocates, the witnesses, the members of the public who have come along, as well as those watching online. I hope you found it all worthwhile. I certainly have. And on that note, it's now 2:10. And if there's nothing further, the inquiry is now closed. Thank you all very much.
Thank you.
Goodbye.